Yeah.
event?
Yeah.
Your event?
Yeah.
Until 9:30.
Or are we using these?
I think we have these. Are these working?
As long as people can hear.
Yeah, you can turn them on.
For
How do I turn it on?
audience.
This?
Just hold it.
Okay.
Test it. Test it. Test it. Test it.
Nope.
Sounds like
Is it on? And then
Oh, okay.
yeah, appreciate it. Okay, thank you so much. Good morning. Hi, sorry for the delay, you guys. You know, it's always technical difficulties in the morning, so All right, welcome to NDPC on Teams and in person. Thank you for attending. How we will work online. If you have a question, please raise your hand. You can also put it in the chat. And we'll call on you. Chat feature is on, so if you have any questions, you can write them in the chat. I'll answer them and ask the guys as soon as we have a little break. In person, if you have a question, you guys can shout it out, raise your hand, do whatever. Hopefully we just don't interrupt the guys in the middle of their talks. Remember, this is an open forum. Be kind and respectful. No calling out names of specific people or companies. Our board members of NDPC, I'm going to have you guys stand up when I call your name if you're here. Our president now, just so you guys know, is no longer me. I am not the president of NDPC any longer. We now have Trish Gibson as your president. So I will be sending out an email introducing her. You guys all know her, but just letting you know that if you have any issues, questions, comments, concerns, direct them to Trish, no longer to me. Our vice president is Catherine Nelson. She is also out today. They did talk me into being the secretary, so as of right now, I am the secretary. Hopefully that will change soon. But I am the secretary, and then treasurer is Sean Ellis. He is also not here. Our directors, Sue Hare Sage, Nicole Marley, Dalton Hooks, Trudy Johnson, she is here. Kevin Kamsher, Miguel Delgado, Glendalee Jackson, Dr. Matt Keok, and Brady Davies. So if you would like to get a hold of any of our board members, those are the people that you can reach out to. I also want to give a shout out to our event. Oh, hi, Sue. Sorry, I didn't realize you were here. I also want to give a shout out to our event committee. We work really hard to get stuff done. And when I say hard, I mean 10, 11, 12 o'clock at night. We're working, we're doing things. So Trudy, Laura, Dolores, who else is on the committee? Kim, she's not here. Kim, Trish, Catherine. Can you guys please stand up? I just want to say thank you because we do work very hard to get this together, to get our NDPC gala together. We do work long nights, and we have a chain thread, which I apologize if anybody's on it because we do text at 12 o'clock at night and probably wake you all up with our thousands of texts. So thank you, ladies. Okay, so our website. We have a new website, so I'm very excited to introduce our new website. Our web address has changed. It didn't change a ton, but we are now nvndpc.org. You can go to our website. If you pay through the website for membership, you will be given access to our online portal. Our online portal does have all of our lectures for probably the last, I think, 2020. Those are all in there. So all of those are in there. Moving forward, starting at this meeting, this presentation, all of our presentations, any of our handouts, will also be uploaded onto our portal. So once you guys have access to that portal, you can have access to any of our videos and documents for the entire time you are a member. So that is a beautiful thing. nvndpc.org instead of .com. That's what it used to be. Along with that, we have a kind of a new pay system. So if you guys pay through membership, through Gala, any of your event stuff, sponsorships, all of that can be done through the website. So you don't have to, go through, you can go through Zephy, you can go through Zelle, we can still offer those, but it is easier for us to track and to do things if you do it through the website. So that is an option that you guys have to go and do it through the website. If you have already paid for your membership or any of those things through Zephy or through Zelle or any of those, we will give you a password to use so that you can access the portal. That will also be used for the remainder of time that you are a member, and if you continue your membership, you'll still have access to the portal. Once your membership expires, that password will be no longer, and then you won't be able to get in. But for those that have already paid membership, you will have access to the portal, and we'll be getting those passwords out to you. Membership. So we are in January. We are the start of the year. Remember, NDPC is whatever month you want to join, you are good for 365 days on that day. So if you join in January, you're good till next January. If you join in May, you're good till next May. So we have membership forms in the back. We try to keep them inexpensive so that you guys can afford to come here and learn and enjoy. Adjusters that have or would like CEUs, those memberships are $100 each, or your corporate company can pay $600, and that includes 10 people. So for CEUs. If you do not need CEUs, we do have a corporate membership for $300, or for individual people for $75. So and that goes for the entire year. Those funds, those membership monies do help us put these events on, put our gala on, do some of our fun mixers and things that we do. It allows us to offer you guys breakfast in the morning. So we thank you for your membership and your support to NDPC. Okay, the annual gala. So we have our gala scheduled for next Friday. It is here already. So if you have not signed up, I think we have until this Friday to make sure to get all your paperwork and documents in. If you are a sponsor, please make sure we have your logo. If you are also a sponsor, we would like to take your swag so that we can put them in bags. So please reach out to any of the committee members so we can get those in the bags. Am I missing something? Also, anyone that comes to the gala is eligible. You can bring raffles if you would like, your company, anything. So if you guys have a raffle, we do a silent raffle, so we're not yelling out numbers throughout the meeting. So I put them on a sheet. Everybody has them at their tables, at their seats, so it'll all be listed. So if you do plan to bring a raffle to the gala, please let me know. I'll put it on the list. Everyone will be able to see it, and everybody can see what kind of prizes they're gonna win. Okay. Sponsors for this event, I'd like to thank the Las Vegas Water District. We're in a smaller room right now. It kind of feels a little closed in, but we're making it work. So again, open forum, please ask questions. Just make sure to try to keep companies and people's names out, okay? All right, so I do not have bios, although most people know Kevin and Sean. So if you guys would like to give a little brief bio on yourself, you can do so. Sean, Kevin, I'll let you go first. Our board member.
Thank you. Aren't these microphones, if I'm doing this, can people?
No, they're all on. Those are for computer and online.
That's for the
Yep.
event.
Oh, so we have to do that, okay. My name is Kevin Campshire. I am an attorney. As you can see, the logo is different. I took a little hiatus from August to December. I'm an attorney with Scrum Roger. A little about Scrum Roger is Dave Roger, some of you may know, is the former DA of Clark County before Steve Wilson. He's the general counsel for the police union, so that's the bulk of the business that we do. Tony Scro, a good friend of mine, a very high-profile trial attorney, a lot of in the criminal world. He's been trying to get me to come over and establish a workers' compensation division for years. Finally, I caved and did it. So I practice in workers' compensation, as well as I've gone back to do criminal law as well, which was a wheelhouse of mine in my former life. The rest of you know pretty much my history. I'm not going to go through my entire bio, but outside of the practice of law, I'm an advocate in other areas. I'm on the executive board of the Anti-Defamation League here in Nevada. I'm also on the National Commission. And I am the former chair of the LGBTQ section of the state bar. I'm a member of the Jewish, Matthew. You're late. I am now a member of the Jewish Bar Association, which was recently formed. I'm on the board of governors with the Nevada Justice Association. Received awards from them, and on the legislative committee, and so do a lot more advocacy work than just for injured workers. Recently passed my specialization exam, just like Sean. Yeah, you're a specialist? Yeah. And so happy to be back in the world. And if you need my contact information, just let me know.
And I'm just Sean. No, I'm just kidding. So Sean Meng, my partners Dalton Hooks and John Clone and I started our law firm 8 years ago, coming up on 8 years. We work on the defense side, representing third-party administrators, self-insureds, and insurers in industrial insurance actions. We do a little bit of ancillary practice areas. We help out our clients with anything they sort of need, and we also do subrogation is a big part of what we do at our firm. We have 30-something attorneys working for us, and several law clerks, and a bunch of staff that are here to help out with all aspects of industrial insurance actions. We represent before the administrative courts, and I'm a super work comp nerd. Love what I do, and people that I work with, including many of you. We work with Dan Schwartz and John Lavery, who have been kind of titans in industry. John Lavery recently took a step back and is trying to work his way into retirement, if we'll let him. Can they not hear us?
Yeah.
Probably because it's a Mac, huh? But we work in this industry each and every day. Our firm is strong on the core values, which includes answering our phone and making sure that we provide expert level advice and resources to the majority of you. Work across the aisle from Kevin. Have been for how many years have you been doing it?
Since 2015.
Yeah,
so
so
long
over
time.
10 years, right? And I've been doing it for I think 16 years now. For a brief period of time, I worked on the other side of the aisle and did some claimants representation. I worked with Laura Sanchez over here closely. It was a fun time. I told her I was going to call her out today. But the purpose of our presentation today, can they hear us now, Crispy?
I'm not hearing anybody
I'm
say
stalling if you guys can't tell.
If you guys can't hear, please let me know, but hopefully that worked.
I don't know, because I'm only sharing this aspect of my screen.
Okay,
Maybe
no,
it'll-
I don't care.
Yeah. So the purpose of today's presentation is to talk about ethics. And Kevin and I have given this, I think, probably for the past 6 or 7 years, right?
Yeah.
6 or 7, right?
Didn't we start the COVID year?
We started the COVID year. I can't remember if we did
now.
one before 2000, like in 19. And then I know that I got COVID from going
From
to
me,
from
you
you,
claim.
yeah, from this presentation. I don't know if y'all have been here before. I've probably talked about it every year since. But I showed up hearing about this new illness that was in the air.
And I got back from Miami.
Yep, he was just back from Miami.
Yeah.
I rode up there.
At a party.
Anne was on the plane as well. I called up Anne the night before. I was like, I don't know what we should do about this. California's talking about shutting down. So I showed up in a parka with salad gloves and a mask on, and everybody thought I was ridiculous. This was before masks were cool for that brief period of time there. And I was like, I don't want to get sick, I don't want to die. So lo and behold, I got sick, but I didn't die, so it's good. But I think that all too often, we've talked about this several times, we talk about sort of all's fair and love and war, and it's just business. And we get sort of detached from the human element of what we're doing here. And on the claimant side, they're much more in touch with the human element. On our side, it's much more about business, right? And we get wrapped up in lots and lots of claims. As an attorney on the other side, you also get sort of jaded with the volume that you deal with in your caseload. And it's easy to become detached. But today's presentation is about focusing back, getting back to kind of the human element, making sure that we're doing what's right. And that's kind of going to be a theme today. We've redone some of the slides to make it more about that, more about the general idea of ethics in business, the general idea of ethics in our day-to-day life, and how that ties in with what we're doing all the time as we sort of serve two masters, right? All of us here in the room, I don't think any of us are just the claimants, and I don't think any of us here are just the direct owner or shareholder and in charge of just that money on our side. But we end up serving two masters in all the aspects of what we do. Broad overviews, Kevin, do you have anything else to say about that?
No, I agree with everything that you said. With ethics, though, I always say the same thing in the very beginning of each presentation that I've ever done. I did an ethics presentation. Remember, DIR invited me. They never invited me again. They invited me to do an ethics presentation, and it was all about, ethics. So you're going to see from a slide is like, right and wrong type of thing. And where the irony of that statement is that ethics, where I think something is right, okay, or I think something is wrong, and I only speak for attorneys, okay, because I'm not an adjuster, and so I only talk about attorney ethics, is that, what the things that he and I have to follow. And so what I think might be unethical, now there's certain things that are more black letter unethical, stealing money, things like that. But how we litigate and certain things and pleadings we file and different conduct and all that, I may think something is wrong, okay, or I may think something is unethical, but that doesn't necessarily make it unethical just because I believe that. And I've always found, and again, I will say this again, okay, ethics, okay, is specific to you. There are certain laws and certain regulations you have to follow, and like with lawyers, we have to follow the professional code of conduct from the state bar. But the reality is it's specific to you. And so, some people get really agitated during conversations like this because there's not always a right and wrong answer. I'm going to give my opinion, which might be opposite of his opinion. That doesn't mean one of us is unethical. The other thing too is you do not litigate ethics, okay? That is not for you to go to court on because someone is being unethical, okay? There's no place for that in court. And so anyway, I hope you we did change the presentation a little bit, so it's not just the same.
I think that when people hear, and even other attorneys that practice in other practice areas hear, how many hearings that I go to each week, they just think, man, you must be the most litigious person out there, right? Because we are litigating a lot. I'm ultra competitive, right? And Kevin's seen me at my most competitive. I wouldn't say that he's seen me at my worst, but he's seen me get
Yes, I have to actually win.
Yeah, oh yeah, right. Okay, we could go back and tally up the record if you'd like, but no, but we are ultra competitive. We're zealous advocates for our clients, but I can tell you this. I've never really been in a situation where that I looked at Kevin and questioned whether he was acting ethically. And we'll get to it in a couple of slides, but there's guidelines that help us with that and keep us from what he was talking about, litigating the ethics of things. Our ethics are nothing that the law should ever get in the way of. In fact, it should help us with it. What's interesting about our practice area, though, is that it's not necessarily like criminal defense. It's not like ordinary civil practice. Because of this slide, which I kept in on purpose, Our goals, our general goals on each side of the fence are generally the same, and that is to ensure the quick and efficient payment or litigation of compensation to employees who are injured or disabled at a reasonable cost to employers, right? I know my partner Dalton Hooks, whenever he gives a presentation, he talks about, not letting, the bad apples spoil the whole bunch. And it's true that can happen, and it can taint and jade the way that we view, the next claim. But it's our obligation not to allow that to happen, to be professional and not to let that take place. And then also to keep in mind what the overarching goals of our day-to-day are, and that is to get through these claims, to vet out and make sure that the non-compensable ones, aren't creeping in there, and then to work with all parties to make sure that these things get resolved and through the process, and the appropriate benefits are paid out quickly and efficiently, and it's right there in black letter law. I guess I'll let you start through this one, Kevin, and start sort of going through the list.
Okay, so general ethics define they're a system of moral standards or values. Again, so morality right there is different from one person to another. Ethics also refers to rules or standards governing the conduct of a person or profession. Of course, would be he and I, and or adjusters, even doctors, what have you. Ethical standards vary between individuals and organizations, correct? Okay. Now, interesting from a legal standpoint, you have to follow one set of code of ethics. You don't have a choice, but you can add to it. There's all kinds of different things you can do, but you have a baseline. Again, I can only speak for the legal profession. I was a performer before I became a trial attorney, and so we didn't have ethics there. No, I'm kidding. An action considered ethical by one person may not be viewed as ethical by another, which is what I just said. And corporate executives set the ethical tone for their organizations, okay? Which again, if you work, some of you work for large companies, and so if you have someone at the top or shortly, right below that is not ethical, and they're teaching you unethical things, more likely you are going to be empowered to do the same thing.
Yeah, and just to speak to that last point, it's been interesting as our law firm has grown to see the way this has become, more and more of an issue that we have to be hyper aware of. When we started out, I think we started in 2018, we started with, 10 or 11 people. I think we had 10 folks and then one part-timer that we started. And it wasn't really an issue to do the ethical oversight in our organization at that time, because it was sort of like Dalton had his team of a couple people, I had my team of a couple people, John had his, and we all knew where everybody stood from an ethical standpoint. We weren't worried about creeping into the gray area or creeping over that line. We now have, 100 plus employees at our firm, and so our obligation at the top of the firm has become more and more serious about knowing what's going on, because it just doesn't roll downhill, right? In fact, it rolls the other way, it rolls back uphill. In the law, we have principles in the law that dictate that exact thing, that attorneys are responsible for all their staff under them. But in your everyday world, you have to deal with the same thing as well. The moral and ethical obligations of each of your subordinates is your responsibility to oversee and to ensure that they're not getting sideways there.
I just want to add something to that, and I say this every time, I'm going to say it again, is that this is, why, so one of the reasons I joined NDPC is so people mostly in the insurance world could get a perspective of something they do not hear, okay? You just do not hear it. My colleagues don't do it, okay? I volunteered to do it, and have continued to do it, but one of the things that Sean talked about ethics is that, and I believe this resonated, in the beginning when I would first talk about it, is that it is none of your business what kind of ethical considerations I have with my clients, okay? And it's not actually for you to get involved. And so what I'm doing as a litigant and as an attorney has, again, my interests are for my own client. And so if I believe I need to appeal this, do this, say this, do whatever, That is because that is what is my ethical obligation to my own client. And I think a lot of times what I have found in the, over 10 years I've been doing this, is the insurance world, okay, adjusters, even like a lot of the bosses, because they've been doing it for a long time, so I think they know everything, okay. But not you, Ann, no. No, is that they don't understand that, is that, well, this is the way it should be done, and this is all that. I'm like, but that's not, you're not a lawyer, and that is the biggest difference, okay, I mean, there's many differences, but it's a huge difference between being an adjuster or a claims manager or what have you, and actually being a lawyer representing the person, because that your ass is on the line in order to actually represent them ethically, okay? And that means how you choose to do it. Not all of you, and you don't have to understand it, and I don't expect people to necessarily understand it, but do keep that in mind, that many things of what attorneys do are because that is what the client wants. An example, okay? We're gonna talk about de factos and whether or not that's ethical, things like that. Every time I'm here, we have so many people being like, well, why don't you appeal it? Why don't you call me? Why don't you try to take additional steps and things like that? Because I have no ethical obligation to you. I have an ethical obligation to my own client, and if you're not gonna respond to something in 30 days, what does my client want to do? Pick up the phone and call you, they'll take you to court, things like that. So please keep that in mind, that it is about your ethical responsibilities to your own client. Not that that means you don't, you be difficult and impede the process and things like that. And again, I've represented almost 10,000 people, and like Sean could attest for this. I have a record of, we move cases through the system all the time. So it's not about being difficult to work with. And I'm a lawyer, I'm not in the insurance world. So that's the benchmark. So I know that's a really long-winded answer. Oh, you want to make a comment? Ann does know a lot, though. She does.
Yeah. Comment,
Forgive me for being late. Everything he says, but on our side as administrators, our ethics are different. Our ethics are not for so much our client as it is for you and your license. It is for you and your business. You cannot lie, you cannot misrepresent, you cannot intentionally delay. You can't do any of those things. So if you are on a de facto, you got 600 claims, 9,000 mail, everything de facto shit happens. That I understand. But if you're waiting until the 29th day, that's not ethical. If you're looking at a PPD and it's a 2% and you know it's wrong because it really should be a 10 because it's a 2-body 5 and you offer a 2, that's not ethical. Those are the things. When your mama says do right, always. That's what you have to do as an administrator. Do right. Do right. Your business is not Kevin's. Your business is not your defense. Your business isn't that. Your business is to do right. Doesn't feel good all the time, doesn't reward you ever, but it is what your business is. Okay, that's mine.
Yeah, and I agree with both of them. I'm gonna make it my responsibility to knock Kevin off his soapbox every few minutes here so we can move through the presentation. We are gonna take a little break at the top of each hour, just so that we're not, talking too much. And interrupt us like Ann just did. We want that. We want you to do that, so that this is more of a discussion. Otherwise, it just becomes us kind of pontificating and just listening to ourselves talk up here, which we'll do all day long. Kevin and I will listen to ourselves talk all day long. But what they're indicating, and they're sort of back and forth, right? And it's because this is an awkward line that we walk. Being professionals who are governed by a code of ethics, by law on one side, and then also having like our moral, ethical obligations that we've developed ourselves on the other side. At certain times those don't fully line up. When you're representing an individual, it's often awkward and it gets in the way. And there's been a handful of cases that I know that Kevin has withdrawn from due to his own ethical obligations of law, his personal ethics, right, and his client's ethics getting all jumbled up and against each other. And there's times, and we'll talk more about it in a little bit, but there's times where that happens, especially on that side. On our side, since we're representing companies, right, it is a little bit, it's a little bit easier in that regard, but we'll talk about that as well. But these first few slides, we're setting them up because we're talking about just your personal ethics that you develop. When I was in college, getting ready for law school, I was,
2 years ago.
yeah, what, 2 years ago? Yeah, a couple days ago. Ann can't even believe that I've gone to college already. He thinks I'm Dennis the Menace.
You are.
Right?
You are.
Just thinks I'm just the kid next door. But when I was in college, getting ready for law school, I decided that I didn't want to pursue just strictly business, which was my major in college, but that I wanted to go to law school. They recommended like a cluster, almost a minor in pre-law, and one of the classes that I had to take was ethics, right? And we talked about all the big hairy issues, right? We talked about all these the dilemmas that you kind of hear about. We talked about the Jews in the basement, right? And whether that it's okay to lie in certain circumstances. And they really called us on it. We had to present. We'd be called up. They did the Socratic method, and so they would call us up and say, "Hey, I'm going to make your personal ethics, kind of on edge here." That class all dealt with honesty, with integrity, responsibility, respect, courage, right? All of those things that are personal attributes that are called on the carpet, and each and every one of us are called on these types of scenarios each day. Whether it's driving, right? Do you let somebody in even though it might make you late? Do you have obligations to individuals where you're going, right? Are you gonna hit the brakes and let somebody go? Or does it become more dangerous to the other drivers, right? These are all ethical concerns that we all probably dealt with on the way here today on a personal level.
Okay, so real quick,
Yeah.
before we continue, I just have something online.
Yeah.
So it says, as case managers, we want parties to read their files before filing a de facto.
Mhm.
It is not a de facto if you have the information in your file but you have not read it. Others say agree clogs up the hearings office with unnecessary litigation, and also with us requesting dismissals on matters that are not de factos doesn't help when some plaintiff attorneys also then wait until the day before or the day of to dismiss.
I love the comment, but that's frustration, not ethics. Simple as that. I appreciate exactly what you're saying. I too suffer from it because I am so shy and demure. I do at times call the attorney to say, WTF, really, you have this. But that has nothing to do with ethics. That has to do with a break in our system and frustration and so much work we can't stand it. The point of that would be if you intentionally de facto something because you don't like Kevin. That's unethical.
Or my client.
Or, no, we love all your clients. The clients aren't the problem.
Well said. Sound like it.
But you so have to, I do appreciate what you're saying online. I wanted to stop for a minute because you're right, but that's not ethics. Ethics is doing the right thing. It is doing what you are bound to do by your law and by the license.
And I'm just gonna add one thing to that, because this comes up every time, is that we can all talk about the one-offs. And again, I've represented almost 10,000 people. So what we've done with NDPC is we're not up here to talk about the one-offs, because I've got my list of people that I can come right back and say, well, let me talk about this person and this person and that and all that. But that's not the purpose of this, okay? That's not the purpose of NDPC, and like Ann said, that's not necessarily ethics, okay? I could pitch it back and say, well, but if it's not the fact, I mean, you just don't know what's going on that end. But I will tell you this, okay, is that every time we give one of these presentations, that comes up every single time, okay? And my response is simply this. For the 10 years or plus that I've been doing this job, okay, I've worked for the two large, before I went on my own with Scrub Roger, okay, is that I work for the two largest law firms in the state, Shipman Stone and GGRM, okay? So you're talking in both of those cases, okay, 40%, it was consistent because I tracked it and I brought it to the senior appeals officer every quarter, okay? 40%, okay, of my hearings at the HO were de facto, and that was consistent from Shook and Stone and GGRM. So if you want to talk about the individual problems and things like that, I'm happy to do all of that. I don't come up here and speak for my colleagues, but understand is that when you have 1,000 files, okay, and you decide to answer the letter, okay, you know, outside of the law, and we're supposed to jump and do something real quickly and do it all because of you and all that, that's not necessarily how that works. I respect that question, but you also have to understand is in the aggregate, and looking at it from 30,000 feet above, okay, that just doesn't pan out like that, okay? So we just need to be real, but I agree with Ann that that has nothing to do with ethical responsibilities.
And I'm going to disagree a bit with both of them. It may, right? I mean, when we're looking at broad strokes, probably not, right? When we're looking at broad strokes, generally speaking, it probably has more to do with the volume that people are dealing with on both sides of the aisle, right? But it might have something to do with ethics. Ann brought up an ethical situation where it would have something to do. Maybe an adjuster is purposefully waiting, purposefully delaying because of some tactical aspect that they see on the file. That's probably not regular, but that would be an ethical concern, an ethical dilemma. And maybe a claimant's attorney is purposefully filing to try to leverage. Now, I know with Kevin, and I'm not going to say that he's always had more cases than he's necessarily wanted, but he's always had a lot of cases since I've worked with him. And maybe there are a few where that they get away from him. And so with Kevin, I know that it hasn't been the case. But maybe there is a claimant's attorney out there who's purposefully filing to try to work up a case in an unethical sort of way to try to make it so that it's expensive and they can get a settlement out of it or something like that.
Or they don't read their file. I mean, you're right. Or they don't read their file.
Right.
Could be.
Right.
Right.
And
their assistant's gone. Or I mean, who knows?
Right.
Yeah.
On that's in the professional sphere, right? We're identifying some ethical issues that could be arising in the professional sphere. But there also could be issues on the personal side, right? And they end up overlapping,
Yeah.
right? Maybe this is a respect issue, right? Making decisions in a manner that treats people fairly and consistently. Maybe you just don't like the claimant. Maybe the attorney just doesn't like the adjuster, right? Now that is a personal or general ethical issue, right? And we would hope that everybody acts properly in that sphere as well as in the professional sphere. Moving along, stated generally, acting ethically is simply doing the right thing. In balancing conflicting interests to make ethical decisions, it is often useful to consider the answers to such questions as the following. What are my legal duties and contractual obligations in this situation? What benefits and what costs or harms does each course of action produce for each involved party, and which alternative leads to the best overall result? Does one course of action best respect the moral rights of all the parties? Is one course of action fairer to all the parties than are others, right? Than our other courses of action? So I dealt with this actually this morning, right? On a general side of things. I thought I might be late because I got called by my son's high school, and they said, "Hey, the police have your son in their office," and then they said, "Don't worry."
That's why you called me.
Right. I did text his background, but as a friend as well, but and a co-presenter. But the police have my son. Apparently, he was physically assaulted by another kid at school yesterday. He didn't tell us about it because he's 16 going on 17, and so of course it didn't matter to him what mom and dad knew. But I find out that the police have my son. They're asking him to make a statement. I'm like, okay, I'm on my way down, right? I know that the school is going to have him sign something and do some adult type things, so I needed to be down there.
That's when an attorney comes in.
But right, so it kind of helps out sometimes. But but I go down and I find out that this kid that assaulted him has done this like a ton of times, and nobody is talking about it because they're fearful of retaliation. My son was kind of courageous enough to be like, hey, like this has to stop at some point, but kind of put himself in a dangerous circumstance. I look up the kid on the way over. My son's texting me now since I'm living with him, that he didn't tell us. And so I look up the kid and he plays football and basketball, and he's 6'4", 330 pounds. And I was like, oh, this is great. My son is 5'8" and weighs about 125 pounds. He's a soccer player. He's a great athlete, but not really a match, right, for this guy.
I'm already angry.
Right, and so all these emotions start flowing through me, right? I'm super angry. I'm like, who do I need to call to put a hit out on this kid? Just
Yeah.
kidding. That's obviously a joke.
For real.
That's obviously a joke. That would never happen. But then I'm like, hey, let's throw the book at this person. Like, I'm going in, Mr. Attorney, right, ready to get justice, right? In a prior life, I did criminal defense, and so I knew exactly what the pain points were on a kid like this. He's in with the police, right? So they're going to ask me about pressing charges, and I walk into it thinking, yeah, full extent of the law, drop the hammer. But then we get in there and we start talking with the police, and I start thinking about this kid's life, right? And okay, he's a great athlete, and we're talking the results of this. If we press charges, they have video of it. If we press charges, automatic expulsion, right, for this kid, and he's done, right? And so I'm like, I asked what the video showed, and what it was the kid hit, not soft, like, but hit my son on the back of the head. And he had done it twice, and he called my son a snitch because my son didn't say anything, but the teacher did. And so I'm like, all of a sudden I have this big ethical dilemma. And I'm gonna leave you hanging because I'm not gonna tell you exactly what happened. But all of a sudden,
Really?
I had all these, maybe if you guys stay with me and don't leave. No. But I have all these considerations. Now I've got this kid's future that's kind of like in my hands. I've got his actions, I've got my son's safety, I've got the school and all the other kids, right? And so now we're deciding, you know, what do we do here? And so I explain that to my son. Hey, this isn't super easy, right? This isn't just a knee-jerk reaction because you're gonna have to live with this. You're gonna have to think about this later, right? You're gonna have to think about what happens to this individual because he's a human that you've dealt with, right? And so this is just this morning. I also have to think about the fact that I may be late to this presentation,
I'm so sorry.
right? So I'm reaching out to Kevin like, hey,
I'm texting.
you might have to start this thing up. I found out in the middle of it, I find out from Christy that, hey,
Sorry.
we need some tech help here. Make sure you have a laptop. And so all these things are going on, right? While I'm also having to think about my law firm, right? Putting food on the table, the business aspects of what's going on, right? Check the corporate bank account every morning. All these things. All this is going on, right? And I'm an individual that's caught up in this big ethical dilemma. I also have to disclose that I'm an attorney while I'm going in there, right, to the police, just so that they understand where my representations are, both as a parent, but my legal obligations. And so we just got all of these facets to life. I think that often in our day-to-day in comp, we just boil it down to it's just comp, right? It's just business. But it's the stress that all of us are under is great, right? And when we take broad strokes and we make comments or considerations or say, hey, this law firm is just terrible all the time, or all these claimants are just trying to milk the system, or all of these adjusters are just trying to deprive you of your civil rights or your benefits, right? These broad strokes end up skewing our view, making things foggy, and making it so that we can't make proper ethical decisions on a day-to-day basis because we get tunnel vision. And when we have tunnel vision, we set ourselves up for failure. And that failure might just be that you become unethical and you have to live with yourself.
Okay,
but
but
they
wait,
might be
can we
further
really
reaching.
finish the story?
Just wait, one quick little joke though, okay, is that when Sean reached out and told me about all of this, and we were kind of talking back and forth about what was gonna happen. So he told me the name of the assailant and I quit Googling him too, and I reached out to his parents and gave him my retainer.
Of course, you ambulance chasing attorneys for something like that. Thanks, no conflict there.
Well, we're being ethical.
What's really weird is that I thought you were my attorney because you've given me advice. That's weird that you'd be willing to do that.
So I just committed an ethical violation of my confidentiality. Right. Yeah.
No, we'll get to some of those issues that attorneys face all the time later in this presentation. But it's just one example of how difficult that gets very quickly on a day-to-day basis, right? And it gets that way often in our claims. I've talked about this before. We decided, Dalton Hooks and myself and John went along with it, but we decided, because he doesn't like any of the kumbaya stuff that we do, as he calls it, but we decided that we were going to use an anchor as the logo for our law firm because what we recognized was that employers, right, administrators, right, and employees are all in unsettling times as soon as a workplace injury occurs. So they're in the same type of situation as soon as this workplace injury occurs that I was in this morning. Back on my heels, who's out to get me? Where do I stand? Who's here to support me? I thought my employer was here to get my back. Now they're talking to the insurer or an adjuster. And who actually is protecting me, my interests? The employer is saying, maybe I have an insurance company that's going to represent their own interests aside from mine, right? Maybe I have a TPA that's going to be trying to pull me in one direction, and likely in the right direction legally, but is it morally the right direction? Am I supposed to get my employees back, or am I supposed to protect my own? Right, they're in the same type of circumstance that I was in this morning, right? Where it's just uncertainty. We decided to make our logo, and this isn't a marketing stint here, we decided to make our logo about something that would settle this down. Something that we could provide some stability in a really shaky time for everyone. I know that Kevin can speak to that because when an injured worker comes into him, they're in sort of chaos. They don't know where that they stand most of the time, and they're scared. And I could attest to that because I did something.
Scared, frustrated, and there's all kinds of emotions that are involved, and that's part of being a good claimant's attorney for workers' compensation, is managing those emotions, because you can't be, as the attorney, although I'm theatrical, okay, I'm certainly not emotional when it comes into litigation and things like that. And clients that come to you, they're not friends with TPAs, and sometimes not the employer and things like that, and they don't want you to be. And you have to then manage that of how do you represent your client, and then how do you move the case forward, knowing all of those dynamics. Okay, I always tell the story. So Dalton and I one time had an AO, and it was the Clark County School District, okay, and my client was a bus driver or something, and there was a motor vehicle accident, okay, and she was claiming these various injuries and things. And I remember, okay, two things. My case fell apart during the hearing because Dalton called a witness who was like an assistant or something, and she was sitting on the bus, and so she gave her view of everything. And it was this sweet old woman, okay, that you just couldn't, I tried to make her look like a liar, but it just didn't, it did not work, and so my case just literally fell apart. But my client, because of the interaction between Dalton and I, and then Senior Appeals Officer Michelle Morgando, okay, my client, because Dalton and I, and then Michelle at the time, okay, and even Sean and I can attest to this, we see each other all the time, okay, we work together all the time. So when you see us, okay, like you probably saw us today, okay, we were sitting and talking about all kinds of things. My client came after me after seeing all of that because Dalton and Michelle were making fun of a little place called Mykonos. I don't know if you've heard of it, but it's my favorite. And my client was like, "What the hell?" Pretty much at the end of it, like, "Are you, colluding with the, is that the right word?
Yep.
With the judge and the defense counsel and all that?" And that's far from the truth. I was like, if you only knew my opinion of Michelle Morgando. Dalton and I are friendly and what have you, but this is not how that works. But it just goes to show you of how you have to manage all of that, knowing that your client, what they think, okay? And I've been called out for that because of people's perception that you're like friends with these people. I'm like, that's not how it works. And that goes down to ethics, because does your client want you to go in and do balls to the wall and everything? Of course they do, okay? And you can do it. And I've demonstrated that with being ethical, okay? And not being so adversarial, okay? That you don't get anything done, okay? So.
Yeah. Isn't it time?
It's almost, I have 2 more minutes. I have 2 more minutes. It was a perfect segue
Yep.
to legal ethics, which we're going to be talking about in the next hour. When you sprinkle in with these really complex scenarios, when you sprinkle in an obligation to a third party, which we don't have any claimants here today that are just representing themselves, right? And so everybody here represents a third party's interest, right? When you sprinkle that in, right? Let's say that I have a client at the school as well who has an interest. Well, now all of a sudden, I don't know that I can represent my son's interests. That's crazy, right?
Right.
Because I might have a legal obligation to somebody else that's involved in this. And I'll give you some examples of where something very similar to that
Kids'
happened
parents are your
earlier.
clients.
Right. I mean, something crazy like that, or like the joke that Kevin made, like, hey, like maybe he does have a relationship. Hey, Sean, I can't talk to you even about this, even though we're presenting in 20 minutes together, right? Like maybe I can't talk to you about this. It gets really, really messy. I already gave you how messy it can be. I took a whole class on all the messy scenarios, right? In personal ethics. But once you sprinkle in a professional responsibility to a third party, it gets really hairy, and that's what we're really focusing on today, even though we've already got enough.
Okay, but wait, we have people online that are very interested in your son. They're not gonna be able, they're not gonna be able to sleep, they say.
This is interesting. So what you're asking me to
But
do?
you can deny TTD. Okay.
What you're asking me to do is breach my attorney-client privilege with my son. This is wild. So I'll tell you this: we made the choice that we feel like ensured the most safety to my son. It
Cut off the hands of the football player.
Yeah. Well, I mean,
Assuming guilt.
yeah.
They do these
The problem
things
is that
now
it's
where they put a no contact
Yeah.
clause, and so
Oh, yeah.
both boys
Yeah.
have to. That's the whole thing now. You
Yeah.
both get suspended, and then they have this no contact clause. That's
it's not as easy. I mean, if I wish it were feudal times or whatever, and we could have just cut his hands off, but no. I mean, so the thing that we have to worry about is the kid's got friends at the school too. We've got even if the kid was expelled, then there's lasting repercussions, and so we kind of walked through all of that in a very short amount of time. I literally found out at I think 7:30 that this was happening, or 7:40. And so I knew I had to be here by
Oh my
9. And so
gosh.
we talked through all of this very quickly at the school, and I gave the proper amount of time for it and everything. But it was, but yeah, we had to take all those considerations into effect. And we made the decision that would ensure the most safety for my kids.
Did they agree on mediation too with the boys?
Didn't get
That far?
all the way through that.
Yeah.
We'll find out. And it's an ongoing thing. So we kind of left it a little bit open-ended and made sure that we were representing all of those considerations for my son.
I just want to take a minute because one of the things that
If you're making a decision and you feel something, take a break. I've said it 1,000 times, but that is where, in my 30 whatever years since 1904, when it's a bad problem and I sit down and we talk about it, the administrator made a decision based on emotions. And when you do that, it's dangerous. It's just dangerous. It's wrong because, nobody cries in work comp. We don't cry. But you can't make that decision. And then the other thing, I liked it when I went to school because I whooped his ass.
Before we take a break, I just want to add something to Ann says. Yesterday I was at the RIMS lunch, okay? And I went there, not in my capacity as a workers' compensation attorney, although it certainly helps, but because they were talking about work comp fraud, which is a felony, okay? And I'm a criminal defense attorney, so I went with that
Picking up clients
perspective.
again?
I'm sorry?
Picking up clients again?
No, yeah. And what's interesting is the Attorney General said, okay, I'm happy to tell, and it's so funny, he even made the comment at the luncheon, he's like, I've never had a defense attorney sit here and agree with everything that I'm saying, because people, of course, there's this narrative that the AG doesn't do anything, okay, and all that. And I always knew from a criminal defense aspect and perspective, from a not even criminal defense, criminal law, okay, it's a very different world when you are trying to put someone in prison versus trying to suspend benefits or not pay them or doing something along those lines. So I always knew, the baseline of that. But the Attorney General said, which comes up, which is why I wanted to say this now, is the Attorney General said, okay, that a lot of the referrals they get are so personal, okay?
Yeah.
Now, if the Deputy Attorney General of the state of Nevada is saying that about you as an adjuster or a claims manager, and you're referring things on over about that. Now, in work comp world, okay, and he and I discussed this, because a felony, that means jury trial. Criminal, okay, you have rights. okay? You have the right to remain silent, you have all of that. So versus in our world, you don't have that right unless you're advised because it might, incriminate you or something like that, but most of the stuff does not. Okay, so everybody's testifying. If you're an adjuster, probably don't have to testify, or if you do, probably on the phone, all that. Not so in criminal law, okay? Your ass is there, okay? And you're gonna be testifying about every single thing you've said and done or not done or all of that. And so where the personal comes is that, I remember when I started work on, I used to try to convince the AO that the adjuster was biased, okay? Which I still stand by. Well, of course they are, okay? And the AO was like, okay, next, it really meant nothing, okay? In criminal law, that means a lot, okay? Because if they find out, and any skilled defense attorney, if they're sitting in there and you're in front of a jury and that adjuster is on the stand and you're asking them about their bias and why you call them a liar or a faker or any of those types of things, okay, be ready, all right? And that, the Attorney General talked about that, how that really can derail your case because of those things that the adjuster said or represented. So to Ann's point, don't make things personal. And if you're going to escalate to the Attorney General's office, you're going to find that you have a huge problem with that, because the remedy, okay, when the standard, the legal standard is beyond a reasonable doubt, okay, and the Attorney General and I talked about this, we sucked up the oxygen a little bit in the room, but fine. And so one of the things we talked about is that the remedy is, first of all, you're advised as a jury, here's a jury instruction on what beyond a reasonable doubt means. And if you have anybody up there, any witness up there that's biased, or you don't believe a portion of what they're saying, or a combination of the two, the remedy is to either throw out the entire testimony, okay, or you've just created reasonable doubt and it's an automatic acquittal, okay? So I'm not telling you how to, with your files, but the theme of why I wrap that around is that we, personal, whether taking it personal from adjusters, always kind of comes up. And just because yesterday I was at that luncheon, I wanted to share with you the Attorney General, not the Attorney General, Aaron, but one of the deputies that does work comp, that's what he said, is that so many referrals are personal, and here's how it causes him problems in the cases. So, FYI.
Yeah, and bias, the underpinning for that, right? We learn about this in law school, in our evidence class, and in our advocacy classes, right? Bias equals unethical, untrustable, right? And so as you're handling these claims, understanding that they may end up going to fraud, let's say, right? As you're handling them, understand that those ethical obligations for you to be truthful and for you to be unbiased and handle the claim fairly, right? Those are all being collected in all of your claim notes and everything, and might be called on the carpet in a judicial proceeding at some point. And so you're under the microscope in your capacity as an adjuster, manager, whatever capacity that you're in.
And please don't write it down. Do not write down the personal thought.
Right. So
Or
we
don't write down that, well, fine, if you want to find, now this was years ago, but fine, if you want to file a DIR complaint, and I say this just because Chris is here, okay, so this is not the case in life, but now like that I remember, this was a couple of years ago, there was a particular adjuster who just was, we followed tons of DIR complaints, just kind of as an industry.
What the hell?
And no. And in writing was this email that we ended up producing,
Teams just closed.
another person that, in writing, this person said, well, if you want to go and file a DIR complaint, fine, it takes them, 10 or 12 months to actually do an investigation. By that time, the case will be over with, okay? You may think that, or you may, say that, but I wouldn't put that in writing, because we will collectively produce that. But that's literally something in writing that I was like, so, anyway, I need to stop talking.
Thank you very much. Can I have that, please?
Mine was going the whole time.
Let's take a break, you guys.
Mine was going the whole time.
That's weird. All of a sudden, it just went off. My Teams completely went down.
It's probably because you don't have a Mac.
Yeah, that's it.
She was giving me a bad time.
So, were you a morning? I'm a 49er fan.
Oh yeah. That's why I didn't talk about my personal stuff today.
Not only that, my husband's a Seahawk fan.
Oh,
And we,
it's my wife's family, yeah.
All right, we're gonna take a break, you guys. We'll be back at
Yeah, that's good.
10:18.
I went over to some other 49er fans' house, and I ended up leaving at halftime and just watching on my phone. So I was just
asking about you, actually. I started
oh, I know. It was like, this is Get over that. Yeah, one in here too many. Got it. I was so good. That's good. I mean, my team. I felt like that. I know. That's what I told you.
Well, I mean, yes.
Right.
Here's how we set up the file. Here's how we set up the case management system. Like this. All good now? Yeah.
So it's like,
So it's not the adjuster, it's not the TP, it's not the recorder, it's nothing. If my client says that they won't find, I just say that they leave their agent.
right? Like, where do you want?
Because if I had. So I said, okay, so come back with me and how we're gonna defend that into our amateur. Because it's one of the reasons why, as an administrator, I always, even though I've been doing it 950 years, I'll poll the defense attorneys. And for us, it's a common and fun. Because I know my listeners that always say, okay, do everything but the PPD. Really? Because the PPD is $250. Right. So right. So, you know, and you're like, okay. And so I'm like, yeah. I'm like, put it right. You're like,
Or the fiduciary responsibility.
And the judges don't even do it.
Go on here. Right? Put 30 boxes down.
Yeah, I mean, I have to respect.
And so I wrote the letter. And then when they did, safety net, and they had to move out of state. I've been in just for the last couple of weeks because Rosalind is figuring out there. I hate that part. I'm like, these people, I'm like, you're calling me again? And you know, I think that's the reason we are probably still on television. That's also the reason why we have a problem with is because, you know, I have some of the best in the United States. I actually love rap because they're so pissed off. They're all mad. Okay, find me a couple that is last. I got students that she's having problems with her and she's having problems but I want her to tell the other dog to behave, to teach the other dog how to act. And so I was thinking, not yet. Now once she goes eat and buy the video and park and another agree that it's I know that right. But it's not like I gotta worry about this a mess in my house because I'm constantly low human and so it doesn't matter. It doesn't matter. I mean, my house makes, you know, they're not gonna be dry. So it doesn't matter. And the other thing, it's not about it. It's not happy. It's not an apartment. I've got one more. And my career is person dominant and me. And then I've got a female I love her. And then I got
So what my order was. Because I'm done with doctors in 2025. But they were so good. And so I'm like, let's get it done. So it's 2025. Yeah. And I voiced this therapy it's called Origins. It is just hands-on.
All right, let's go ahead and work our way back to our seats. All right, we are going to start back up for those of you online.
Yeah, but we're gonna have, Kevin back. Yeah. Cause I don't have the hair.
Cancer-free since
No coffee for you.
I'm not sure I'm a crack. I was an extra late because I had to buy one. Okay, what are we talking about? Oh. Are you gonna turn back on too?
Are you starting right here?
Yeah.
Okay.
Once upon a time, there was legal ethics.
Oh, now we're talking about, okay.
Yeah, so on the break, we were talking about ethics, because this, we're all nerding out about it now, because we're
We are nerding out about it.
So I had someone ask a question, and asked me to, kind of start to add another layer of complexity to the whole issue of when you add in a third interested party that you have an obligation to, right? Like each of us have. Often it doesn't just end at that third interested party, and I want to take a poll, but I need Christy or somebody to, maybe Anne could take a look at it. But when you add in an employer, whether you're an insurer or a third-party administrator, right, that adds often a fourth or maybe even a fifth level of obligation. And so what I wanted to know is if any of you industry professionals know the answer to this, which I've often wondered, and that is whether that your contracts with your employers have a duty to defend in them.
Define duty to defend.
So there'll be a provision in the contract that says that you're required to defend their interests. And sometimes that'll be before the DIR, or sometimes that'll be before, any other administrative agency, or a duty to defend if they're sued civilly, right? If you as the third party administrators or insurers have a duty to defend their interests. Because I think that certainly would add to the complexities. If we're dealing with civil, like at one point in my career, I did a little bit of personal injury representation, and I've represented on the general liability side as well, right? You certainly have provisions in those contracts where that you insure an individual or you insure a company. You have a duty to defend, right? You have a duty to represent them, and so when an attorney comes in on behalf of somebody who's in a car accident, right, and they're insurance defense attorney, right? They've been hired by the insurance company, but they have a duty to defend the driver as well, right? In work comp, it's a little bit different, because whether you're a third-party administrator, we get hired by all sorts of folks, but we get hired by the employer sometimes. We get hired by the employer and the third-party administrator sometimes, and then we get hired by just the insurer sometimes. And I've often wondered whether, and I just haven't looked specifically for this because it hasn't been a legal issue, whether that there's a duty to defend the employer, so the insured in the insurance cases, or if that's just something that we provide as kind of a courtesy to the extent there's no conflict.
So I'm gonna say yes, 15 years ago, yes. No, currently. So the TPAs have changed their contracts. So now they don't. The subrogation recovery used to be a part of the claims administration. The legal representation at hearing used to be part of the claims administration. subsequent injury used to be part of the claims administration. Now it's all cookie cutter. All I'm getting is TPA services in accordance with the statutes, and everything else I either have to buy it from the TPA or I have to get my own representation for that. So, and even clauses to the effect that we're not gonna pay your DIR fines and penalties if you, the employer, made us render a determination that was out of compliance with the law. And I fought that with my current contract, and they brought their legal counsel in and I brought mine in, and I said, you have a legal obligation to adjust claims in accordance with the statutes. You should never take an employer's perspective outside of the law. I don't hire you to break the law. If I'm asking you something that's not in compliance with the law, you have a legal obligation by contract to tell me I'm wrong. And if I don't like it, I can take it to hearing. That's my recourse. So we were able to remove that clause, but it's my understanding because of fire and police that other entities that are currently with that TPA have that in there, that the TPA is not gonna pay your DIR fines.
I know, Sandy.
Anything from the peanut gallery? I mean, not that you're not in the peanut gallery, Sandy.
She
But
is.
thank you, Sandy. Anything from the rest of kind of industry, or do we know?
I don't think, when I was sitting there, nobody did, because I don't think an adjuster ever thinks about what their duty is and their duty to defend. When we were talking in our nerding out thing.
I think we have this class.
Yeah, I think when we were talking about the nerding out thing, that's part of it, because first of all, there's two separate sets of rules, one for the self-insured and one for the guaranteed, or the insured. So that's your first separation, and I think Sandy, Water District is self-insured. So I think Sandy is absolutely correct, that when it came to the contract with the self-insured, they define it and pull it all out and everything else. What people need to understand is that it's in insurance, there are levels that are required, and when I always say fiduciary responsibility, that means I'm responsible to manage the money and justify how I spend that money. And whatever ties to that goes. So for example, when she said that about the DIR, etc., one of the reasons when we were nerding, if I have an issue that is complex or whatever, I pull defense counsel. I send it to all my friends and all the defense counsel and say, hey, what do you think about this? I know my defense counsel people, so I know how they think and what's gonna come back to me. I do that not because, well, I do it because I'm also interested in their opinion, because they're brilliant with their legal. But I also do it to cover my own butt. Because if you tell me, and I just recently had someone not in this room, tell me that I should do something that was not correct, in the sense that they were saying that, oh, you can let that ride, don't worry about it. My response was, okay, and then provide me your defense with regards to the DIR, because they're gonna come back and tell me you're wrong. I do that because attorney's E&O is bigger than mine. It's as simple as that. If you make a decision and you're all bold and it's a big ramification decision, you need to have support to that. It's not your feeling, it's not because you've been doing work comp for 20 years or whatever. You need to have that based on a legal opinion. And Sandy was very cool when she said, used to be and now. Today's culture is so different. Keyword is liability. And that is, nobody wants the liability, and the liability is huge. So when you say that, most of us are writing out the right to defend. And we segregate it to, or we outsource it to various other places so that we don't have to pay the ultimate cost.
Yeah. And like you said, so I mean, almost all of my clients who are self-insured, right? They also have to worry about what happens when the claim goes maybe ultra super high, right? And so you end up with an excess carrier that might be involved. And when we're talking about fiduciary duties, right? If your TPA has signed a contract, or if you've signed a contract with an excess carrier, in that contract is going to be another level of duty to ensure that the claim is not spinning out of control erroneously, right? And so there's just all of this complexity in it.
Since I started practicing.
Can I have one thing?
Yeah.
With the, oh yeah, cause that's
What I need is a microphone.
Well, now, so
It
I
helps.
can hear you.
It helps. When it comes to the excess carriers, it's incredibly important that you understand that if you as an administrator get a lot of DIR complaints, you have bad attitude, you have problems with your employers, etc., the excess carrier will know. And the excess carrier has a list of administrators that they will not use. And so you say, hey, I love Annette Corvell. And that excess carrier goes, yeah, but we've had a conversation with her, we don't like her, we're not gonna use her. You can't place your business with me. So when we talk about fiduciary responsibilities, even on a self-insured, I have self-insureds that have $5 million SIRs. They're never gonna get to 5 million, you know, I don't know if I've ever seen a $5 million claim. I think I've seen a 3, but I don't know that I've seen a 5. If they don't like me though, they won't give it to me, and my employer will not be able to get excess carrier. That doesn't work. So when we talk about that, you have to also be aware that it's not just you as an adjuster and your boss. It is so much higher than that, because if you act incorrectly and the carriers say, man, we're not gonna deal with them anymore, then your company will not get the business.
Yeah, and on the other side of things, if, Kevin here, on the other side of things, if the claimant's attorneys just follow blindly the claimant's requests and asks, then they put their own reputation, they create this liability for themselves in the industry. When they start to skirt ethical responsibilities across the board, there's just a ripple effect, there's just lasting repercussions with regard to this. And on one side of it, yes, you have to worry about your, the ultimate cost, maybe not being insurable as a TPA or as an insurer in Nevada, just from the way the industry responds. But on the personal level, adjusters can lose their license, and we're gonna get into that. Go ahead.
I just want to make one clarification in regards to, and sometimes it surprises people, but when you are doing, there's a difference between representing individuals and representing entities, okay? And one of the biggest differences is that it's almost kind of my way or the highway. Like if you are an injured worker and you come and you hire a claimant's attorney, okay, they don't run the show, okay? So if they tell you, go and request this, go and do that, and you don't believe that's in their best interest, the answer is no, we're not doing that. And then you talk about the ethical responsibility is that, is if they don't, like say there's a disagreement, sometimes you'll find it, not so much, it's an easy one saying, well, ask for TTD and I'm working. Well, no, it's not even things like that, because that's an easy answer. It can be, I want to go with Dr. So-and-so, and you're like, I would never send any of my clients to Dr. So-and-so, and if you're coming and you're wanting me to represent you, then we're going to choose the doctors on the panel that I utilize, and if that's a problem, okay, that creates then a conflict of interest, and then I have to withdraw. Okay, so it is not the injured worker that runs the show or drives the train when they go and get representation from a plaintiff's attorney, which is a very different world in regards to, again, I've never represented entities, but that is, if people didn't know that, that's how it is with injured workers representing them on an individual basis.
Same thing with employers.
There's levels of, so in practicality, there's different approaches, levels of sophistication, right, that you're dealing with in representation in our world, but in your world as well, right? You might be representing a mom and pop shop who's never dealt with a work comp claim before, or you might be dealing with a large corporation that deals with it daily and has their own staff appointed to determining risk. And those are gonna be different levels of sophistication with the process. What really can't change, either on your side or on my side, across the board, is whether or not we will tolerate unethical approaches to these claims and I would suggest on a professional level or on a general ethical level. If somebody is being dishonest, right, and it just seems like they're in their own life, whatever it might be, that will certainly creep into the way that they handle claims, and you will ultimately end up dealing with that problem. And we'll reiterate this later, but nothing is worth losing your ethical standing in these claims, right? You have all the tools available for you on both sides of the aisle to handle these claims ethically and to maintain your professional obligations in addition to your own moral standing. And I've never, I can tell you right now, I've never come across a situation where I had to put my own moral and ethical obligations, in jeopardy. It just, the decisions have been made beforehand. If I'm asked by you to do that, the answer will always just be very black and white. It's just going to be no. And we'll discuss, of course, and we'll vet that all out and make sure that it's not just sort of ignorance in what's being asked. But it's just a luxury that I have never been able to afford in my personal or in my everyday life. And I think that it's probably true of Kevin.
It is, I will tell you that is versus the criminal law that I've done and workers' compensation, I think people would be, I'm not gonna talk extensively about criminal law, it's not why we're here, but I think people would be really, really surprised at how broad confidentiality is when it comes to criminal law. Because you get a lot of morality questions there, is how can you defend this person and how can you do any of that, okay? And again, as long as you're not, you still have these ethical responsibilities to the client, and a lot of that is confidentiality. So if they told you, hey, I was really the one with the gun, okay, you don't have a duty to, it's like you can't disclose that to anyone. Now, you can't have them go up and testify on the witness stand and lie about that, and that, you can't do that. Similarly with workers' compensation, okay? So let's say that you become aware, or I become aware, that say it's a claim accepted for cervical strain or something like that, and you become aware, all right, that there was like a major motor vehicle accident, a short time prior to the date of injury that involved that same exact body part, and let's say the TPA and insurer does not know that, okay, and there was no D36 signed, okay. So that I just make a point there, because again, you can't lie. Well, I may know that information, but I cannot, that's one other thing you can't do as a lawyer. You can't throw your own client under the bus, okay, that's unethical. So when Sean talked about withdrawing and things like that, no one ever knows why I withdraw, okay? You don't have to tell, you just say there's a conflict, okay? But there's certain situations where you know that you're withdrawing, but in that particular instance, okay, in fact, I'm forbidden to reach out and be like, hey, by the way, there was a motor vehicle accident like 3 months prior, and do you want all the records and things like that? If it doesn't come up, it doesn't come up. What I cannot have happen, though, is say at the hearing, okay, and they're asked about prior motor vehicle accidents, and if they say no, then I have to intervene and I have to tell the court, okay, stop, because you can't, that's then unethical, okay? So confidentiality is really powerful when it comes to attorney-client privilege. But sometimes you can't wrap your head around it being like, well, wait a minute, but you knew, why didn't you say anything about it? Well, there's a reason, but I just can't help my client perpetuate the lie and what is called perpetrate a fraud on the court, or opposing counsel, or anybody else.
Yeah. Your duty is candor to the court, right?
Yeah.
And to reach that.
Yeah.
I know that Kevin often, for practical purposes, draws kind of a divide between criminal law and what we do in our everyday practice. But they're closer than you think. The analogies that they draw in law school are easily defined with criminal law, because it's sort of like the Perry Mason type law, right? But when Kevin is asked questions like, how could you possibly defend this criminal, right? I get the same types of questions, sorry, industry, right? How do you sleep at night representing these folks that are denying benefits, right? And the answer that Kevin gave and the answer that I give is the same. It's on a really, really comfortable bed. No, I'm just kidding. That's not the answer. That's not the answer that we give. That's like a terrible thing to say in that presentation. No, the answer that we give is, we hold the state, if they're a criminal defense attorney, or we hold the claimants to the standards that they're required to prove their case, right? And it makes it's what Kevin's kind of alluding to here, where it's like a little bit different to operate on the opposite sides of this, because it makes our job really easy when we say, hey, the burden is yours, claimant. Like, our obligation is to defend, and I always refer to it as kind of the sacred amount of money that the state obligates us to hold, right, and to reserve for injured individuals. It's our duty to defend that. On a criminal aspect, it's their duty to defend the Constitution and the constitutional rights, right, of those individuals. And so while that there's an allegation, right, or there's a claim for compensability, right, it's our job to make sure that claimants, right, or accused individuals in the criminal world, right, but it's our job to make sure that claimants satisfy that burden, right, in order to get those benefits. And so I don't find anything, I don't find any real moral issues generally with my practice of law, with my representation of you. I hope that you don't find anything sort of morally repugnant or anything that's morally at issue or ethically at issue with your job generally.
I just have a question.
Wait, we need a microphone.
I'm coming down. I'm a little slow.
Kevin has the microphone. I didn't even think about it. I didn't even think
Broadway.
Good thing we have you.
So from an ethical standpoint, I come across this often, so I'm just wondering from both sides. You have a client that has had an injury, whether or not that injury is in question, they've had an injury, they've had treatment, let's just say cervical spine or lumbar spine. They have declared on their D36, they have no prior injuries, and it becomes apparent at some point, maybe 6 months, maybe a year into the claim, after they've had all this treatment, that they had 6 MRIs, they had been treating for 2 or 3 years. From an ethical standpoint, I as a case manager will get those records and give them to the treating physician to be able to make a determination. They, if they're gonna treat the patient, should have all of the appropriate information. From an ethical standpoint, how do you guys from each side handle that? Because the injured worker's attorney has to do something, right? Or the defense has to do something with that information. I'm not sure how you guys handle it, because it does come up, and I just made my mind that my job is to get the medical information because it is appropriate for their treatment. Give it to the treating provider and let them make the determination. And then that's the end of my responsibility on that. I wondered how you guys feel.
Right.
Oh, thanks.
Don't you worry. I'll say the way that I handle it is first I find out, and then I'll pass it over, because the scenario that you're painting is that we know about it, and maybe we don't know whether Kevin and his client know about it, right? In this certain circumstance, hypothetical. The first thing that I would do is ask whether I have your authority to notify opposing counsel, because I think that will be that's generally the best course of action. Right. And so I'm gonna say, hey.
Nurse case manager, not adjuster.
Oh, right. So I'll ask the adjuster.
Yeah, you're gonna come to me and say, hey, Cody said something.
And I would assume that you would know.
Yeah,
you
I
operate
give
on
it to the adjuster, they're aware.
So I'm gonna ask my client, hey, are you okay with me disclosing this to opposing counsel? Because that's my first ethical concern, is my duty of confidentiality with some newfound information like this. And generally, I've found that that's the best course of action unless there's some other sort of circumstances. Maybe it is a real fraud type case, or maybe it's just the type of case where they didn't think it was important. So I'll ask those questions and get authorization. And then generally speaking, I would reach out to Kevin, and I've done this with Kevin probably more than twice, where that I've had to be like, hey Kevin, do you know about this type of a deal? And then it becomes Kevin's kind of ethical dilemma as to what he's going to do with that information.
Yeah, and I'm gonna tell you, so Sean just used the F word, fraud, okay? And my experience is that, so this is a good example, okay, is that client signs the D36, which is a form. Now, by the way, this also came up yesterday at the conference in regards to forms. Just because they check no doesn't mean they're committing fraud. Same thing on a D6. Just because you sign that you haven't worked under penalty of perjury, that's not conclusive, fraudulent behavior according to the Attorney General. Okay. Now, that said, is that generally now, here's a very vague legal answer. It depends. Okay, because Do we know about it? Do we not? Like, what are the circumstances? I will tell you, generally, when this comes up, we don't know, okay, because they haven't told us either, okay? So then it becomes, how do we go forward from there, okay? And it's mostly, what kind of conversation do I have with my own client? But I'm gonna tell you is that the immediate knee-jerk response, and maybe rightfully so, is that they're committing fraud. And that they're lying, and they're intentionally deceiving, and they're doing all that. That is where all, okay, conversations seem to go. And it's not always the case, okay? And I don't believe that D36 is fraudulent, okay? But it really just depends,
And
okay?
if it was one treatment 3 years ago, like that's different than if
Well,
it was
maybe,
6 physicians.
maybe I gotta
or a
speak
year
more
and a half.
well, I have to speak more generally than that, because you don't know, like, I'm not in their head, okay? And like, when you go into, that's what I'm talking about fraud, is that there has to be criminal intent. And so when they're marking no, okay, you don't know if, like, you're gonna end up having to prove beyond a reasonable doubt that they're doing that to
But if they've
to
said it to every
get a
provider,
benefit. I'm
if
sorry?
they've said it to every provider that they've never had an accident or treatment, like, that's
That
always been
doesn't-
challenged.
But again, whether or not that you could deny benefits under an administrative claim or take action right there, whether or not that's fraud, okay, are you gonna have all those doctors come and testify under oath? You're gonna have it's a very different standard.
Yeah.
So again, the F word gets thrown around a lot, okay, which there is a legal, definition of fraud. But it is, I've had more than one conversation with my own client, okay, in the past being like, well, you told us, because, you're talking an intake, okay, and throughout the claim that nothing had ever happened with the cervical, but it turns out you got into a motor vehicle accident like a year ago, and you signed this form here, and you said that, there was no injury. Now, I gotta leave it at that, because then conversations between my own client, what have you, but I'm not an idiot, okay? And not only that, is that how do I know what that does to my own case. I know what that does to credibility. I know what that does to everything. So, but I can't fully answer what I do on every type of scenario, but that is a really good example that does actually push ethical grounds.
On everyone.
On everybody. Sam?
Yeah, and just
I just
so,
want you also to know for a moment, we don't prosecute, we refer to fraud, but in our 920 years, I've seen one conviction.
Yeah.
So
It's
we
not
don't
even
use
about
that word fraud, and as the administrator, I'm standing right in front of you, sorry. As the administrator, call it out. One of my favorite things is to go, no, I don't have any injuries. Well, you know what, we have a thing called an ISO, and let me explain what the ISO does. It lists all of your injuries that you've had, personal and work comp, in the last 3 years. And I start writing off. I start, well, you had an accident here, you had an accident there, accident here, and I start going through it. And then I go, okay, so now let's take a deep breath, start again. Have you ever injured your back before?
right.
Because you're not the investigator to create the fraud.
And
You're
it's
not any of that. So if they lie to you and you have evidence in front of you, go, you know what? I appear to have, don't call them a liar, don't call them a fraudster, don't do it. But, I appear to have information that's contrary to what you're telling me. This is what I have. What do you think?
It's not a gotcha moment.
No. So-
It's getting
No.
the information.
Get it right.
A lot of information comes at the onset of a claim to the injured workers, and because I'm the employer on site, they come to me with this package. And they're like, what is this and that? And we're going through it one at a time. And when it comes to the D36, I recently had someone come to me and say, a long time ago, and he did his own homework. My doctor's gone. I don't know where I had the MRI. The facility is gone. They told me that doctor went out of business. I have no idea where the records were. It's been 12 years. I know I had something in my back, and they're asking me for all this information that I can't provide anymore because the guy's gone. And I said, okay, well then, that's all you can write was the name of the doctor, and they'll do their research, and the doctor's gone, he's gone. And they said, and now this question, and if you look at the D36, and my God, for 30 years I've seen the D36, it says, Do you have a pre-existing that impacts this claim?
The disposition of the claim.
This claim.
Yeah, right.
That's right.
So he goes, do I put yes or no? And I said, that is an answer that I cannot give you.
Right.
You have to make that decision. He goes, it's been 11 years. I haven't seen a doctor. I've been doing this job for 13. I go, what's your answer? He goes, I'm gonna put no. And is that fraud? No.
No.
He truly believes that whatever herniation he had 11 years ago, that we're never gonna find, because it doesn't exist anymore, has absolutely zero bearing on the fact that he was rear-ended in this motor vehicle accident.
That's right.
And
That's exactly right. And I think that that's,
Also, you have to take into account, just because we work with medical records all day long, we read them for years and years and years, we are a little bit more savvy than the average injured worker. So, when they say have they ever been injured, it could have been, they've just been calling it pain for 20 years.
right.
And going to doctors and all that. So they've never been diagnosed, or they don't know the diagnosis. So they put no because they wholeheartedly believe, no, I haven't, because when they go through work comp, now they have a diagnosis, and now they know it and all that because everybody's telling them, but for years, they could have never known what the diagnosis was.
That's an excellent point. That's for real. That's for real, for real.
And I just wanna clarify, cause I find it interesting, cause of course you're interested. Everybody went to fraud, and that's not at all what I was suggesting as a case manager. I was, just so you know, my thought is like, where does that leave our responsibility? Somebody needs to say to the patient, I'm aware that you have had all of this treatment, and so that the doctor can make an appropriate decision, what is related to the claim, what is an aggravation, what is a new injury, like they need to have the medical information in order to make good decisions so that everyone knows how to go forward. But I just wanted to say, as a case manager, I don't get those and go automatically, oh, this patient's a liar and now I'm not gonna trust anything they say. That's not my job, that's not my responsibility. My responsibility is to obtain the information, make sure that I have good communication between the physicians and the patient and the adjuster so that everybody can make the best decisions. But I just thought it was interesting that everybody else went to possible fraud, and that, you know what I mean? I think that's the world that we live in ethically, is to not get sucked into, I'm just assuming the TPA is out to get me, or I'm just assuming that the attorney or the patient are liars, or they're just trying to get some more money. Like, it is a really, I mean, if you cannot stand and say, I'm doing the best I can do at the job that I've been hired to do, like, anyway.
Get into the job.
That's absolutely true.
Still, we have got through one slide.
Do you have a question?
No,
No.
I was just keeping them on track.
Oh,
Yeah, yep. The, and we've talked about a lot, we'll be skipping through a lot of these slides because we've talked a lot, through the interaction, which is what we want in these. One thing I wanna just, kind of draw a finer point to is, I hate when Kevin ends up defending a ghost in a hypothetical like this,
No, yeah.
right? Because it's rough for Kevin to be like, no, you guys are talking about, right, but, or us defending a de facto,
Yeah.
we're defending a ghost, right? Because it's not a real scenario that we're talking about. But it feels like that, given what we do every day, that you end up kind of having to do that. I'll tell you right now, when I was on the other side, 90% of the clients that came through the door, right, or potential clients that came through the door, were completely ignorant to the work comp process.
Yep.
Right, 90%. When I get involved today, right, it's litigated matters, right? And so that percentage goes dramatically down because now we're in litigation. But when I was on the other side, and it was a fair amount of what we were doing was just non-litigated claims work, walking them through the process of it, it was just this really high number of folks that were very ignorant to the situation. I hesitate to draw on actual personal examples because we have this problem where that we, as an industry and as individuals, we remember the really sexy F-word fraud cases, right? That's the ones that stick out, right? But when I reference, hey, and I do it on purpose, especially in this aspect of this presentation, I can think of a couple of circumstances where that I have contacted Kevin with juicy information, right? And Kevin has got the information and done what was appropriate with it, right? It was completely blindsided type thing, ends up withdrawing, right? Because he would do what was appropriate with it, right? I have had maybe thousands of cases with Kevin, hearings that we've gone to. And I can think of a couple of circumstances where that was the case. And so it's really, we're on thin ice if we're a manager or a supervisor, right, who has adjusters under us. Be very, very careful about these war stories, right? Because you can get somebody ruined in the industry that quick. And then 6 months down the road, you wonder why that they're making all these ludicrous determinations that seems to be denying claims that shouldn't be denied. And we might not be able to accept that accountability of being like, well, maybe it was because their first blush at work comp was me telling them about my 30 war stories about these terrible claimants, right? Anyways, so
and what I want to add to that is, first of all, in today's day, humanity misrepresents continuously for a number of reasons.
Oh, hello. Humanity misrepresents for thousands of reasons. They don't know it's a fraud thing, so it isn't. The other thing is, as administrators, it's not our job to hunt the fraud. It is our job to deliver benefits established under the statutes.
And again, Kevin, in that very limited circumstance, is required to withdraw, right? That's like a worst case scenario where you have to do that as counsel on the other side, right? I've never had to do that on my side, but I can imagine cases where I would have to withdraw because my client was telling me to do something inappropriate or unethical, right?
Yeah, I would. I'd like to say, no, I don't want to manage your claim no more. You go ahead.
But you might have to do that as well with an employer relationship. And I in fact know, Ann, that we've dealt with circumstances where that you've had to walk that line with certain employers. And so I don't know that it's anything that you represent now, but we represent third parties' interests, and so that should always be an option that we can say, actually no, we won't take that next step with you down this ethical road.
So I just want to clarify on something of whether or not I'm required to withdraw. Sean talked earlier about there's certain things that would come up, okay, that would require me. Now, those are all ethical rules under Nevada rules of professional conduct, okay? And some of these scenarios could fall in some of those categories, but who decides that? I do, okay? But I'm gonna give you an example because it'd be interesting to see of what people think is that, and now, thousands and thousands of workers I've represented, I could probably count on one hand. I mean, sub rosa coverage and surveillance is quite common, okay? And it's even more quite common when I view it, I'm like, okay, so they're going to the store, and they're getting out of their car, or they're doing this stuff. But there have been, okay, ones where I was like, okay, they have a 10-pound lifting restriction, and they're like, moving mountains and things and furniture, and stuff like that. They're like, okay. Now, what happens is the doctor that has them on a 10-pound lifting restriction gets that video coverage. What is your ethical responsibility? You have to give that to me if I represent them, okay? But nonetheless, you give it to the doctor. Let's say you do all that. You give it to the doctor, and the doctor views it and says, okay, no, okay, and removes the lifting restrictions, and pretty much a lot of times they'll just release them from care, okay? In regards to that. And then I've seen the video, okay? I would like to find out from the audience in regards to, do you think that I'm required to withdraw in a situation like that? Okay, good, yeah, because the answer is no, okay? It does pose hurdles to represent the person because and the conversation again, they all kind of seem to blend together, but having that conversation with someone once that video coverage is out, okay, and you're like, okay, well, this is what we see, and the person really doesn't have an explanation.
And this
okay?
is where we are, and now we figure
right.
out the next
And so what it becomes is that, can I get another doctor to take your care, though? I mean, that's the challenge. And if I can't do that as an attorney, then what am I doing for you? Can we get you to a PPD? If we can't do that, just because they close the claim doesn't mean, oh, we're done, that's it, what have you, okay? I've had scenarios where no more care, what have you, but they've just rated them and then the claim is over with, okay? But if there isn't anywhere to go, And again, this is up to me. Do I feel that I can represent them effectively and competently and diligently, which are the words, then, then again, that's up to me. But just because something like that has happened doesn't automatically trigger a withdrawal from the attorney. Now, certainly, it does make you think when you represent someone that if someone is going to go, like I had someone, I remember, it's always the dog food at Target. Okay, they have a shoulder injury or something, and they're always reaching for the 20-pound thing of dog food or whatever. But I remember the sling. We only wore the sling to go into the doctor. We only wore the sling to do. This is like my 3rd year of practice in work comp, what have you. Okay, it was just so, the credibility was just gone, okay? I ended up withdrawing from that, okay, because my analysis at that time with that particular client, with the particular evidence that I was presented, okay, and actually it wasn't evidence because we didn't litigate it, right, but it was just what was before me. Did I trust that person to deal with me now? Okay, so, and if the answer is no, that triggers I need to withdraw, because if I don't trust my client, I can't represent them the best way, and nor would you want me to. And certainly, we've all had, we've had adversarial situations with our clients. Like, if you really don't think I'm doing anything for you, you don't trust me, why the hell are you here? Okay, like, you have another option. Go. You can't have that type of relationship. Like when people get all heated, and, I don't trust you, you're not doing anything, and you're not doing any of that. If you really feel that way, then you gotta go. Okay, because if I felt that way hiring someone, whether it's a doctor, a lawyer, accountant, or whatever, I wouldn't be here. You don't have the right just to come and bitch and berate my staff, okay? That's, something that I'm very protective of where I'm at, but what?
That's a technical term.
Bitch and berate? Yeah, that's in the other, yeah.
There's another slide.
Right, yeah. Right.
So what we've been talking about a lot, and what you've asked questions about, is our ethical obligations. In the previous slide, look, we're going backward now. This is not great. Slide 7 of 52. I don't know if I'm going to get through all of them, and we're supposed to be on a break now. But I'm going to give myself 5 or 6 minutes.
Yeah.
So when states, government, and the law recognize that you owe duties to somebody other than yourself, and you're operating in a professional capacity, then they create the legal standards for you, or they try to, right? In every industry, wherever that you have a license or a board associated with an industry, they generally provide these codes of conduct and principles of ethics for you. Now that's very helpful, because those ethics, as we've talked about, get real muddy, and they end up coming to a head and merging and sometimes crashing into each other. Do I represent my client's interest or my own interest, and can I represent my client's interest when I have my own interest providing such a big bias here? And so the easiest place to see that, where we all love to see it, like on TV and stuff, is with lawyers, right? And so that's part of the reason that they have us up here talking about it, is because we face these dilemmas quite often, because we have to go into court, and it's all in front of the video and all of that. Here are the rules of professional conduct for lawyers. These are the sections or the segments that they give us in our ethical code of conduct. In the ways that we are governed, right? And there's tons of nuances to this. This is sort of like looking at NRS 616C, right? As you scan down through it, it just keeps going on and on. And our rules of professional conduct are sort of similarly situated, right? Where you scan through it, they're set up the same way, they're set up like statutes. And the different sections of that are the lawyer-client relationship, what establishes a relationship. You heard a nerdy joke between Kevin and I earlier, where that he's saying, oh yeah, I quickly, signed up the aggressor, whatever you're gonna call him, the assailant of my son. I quickly signed up his parents and him, as soon as I heard, right? But then I made a joke like, oh, I thought, it's like a bar exam joke. It's really, really nerdy. Oh, I thought we had a relationship. So that's a typical bar exam question. What constitutes a relationship? But you might have that issue, as we talked about. What is your relationship with an employer? Right? What is your relationship? Is that trumped by your relationship with an excess carrier, right? That you have to go into here. The client-lawyer relationship, right, it really gets sticky, because Kevin has a bigger issue with this than I do.
he talks to a ton of people all the time, right? And every one of those interactions can constitute, if he's not careful, an attorney-client relationship, right? We have duties to be counselors, right? To counsel with our clients, right? To help them, to lead them in the right direction, right? Individually, outside of court or outside of a representation before a third party. And then we have the requirement that we zealously advocate for our client, right? That we forget our own interests in most scenarios, and that we zealously advocate in favor of our client. Now that's before a third party, whether it's opposing counsel, whether it's to the court, right? We have to represent your best interests, right? Even when ours are in conflict with that, we have to represent yours. And that's what Kevin was just talking about. Sometimes they become so in conflict with each other that you have to break that attorney-client relationship, right? Transactions with persons other than clients. This one gets real weird. It's one of the reasons I'm asking the question. You have a duty to defend, right? So I might represent a third-party administrator, and to the extent there's no conflict, which is the way I say it in court, to the extent that there's no conflict, an employer. But I also might represent both of those by way of contract. And so what do I do with that, right? Who is my client in the room, right? And I might have to, and I have had to do this several times, where I withdraw as representing one of those parties. Sometimes it's strategic to do, but withdraw as representing one of those parties so I can represent the interest of the other, right? But it gets real sticky. I know that when I was on the other side, we would have contracts with vendors or things like that, right? And then all of a sudden the vendor might have a bad relationship, like a marketing firm or something like that, might have a bad relationship with one of our clients. Well, now I'm in a tough spot, right? I have to figure out which one I'm going to terminate my relationship with. Law firm associations, we talked about that earlier, about how that the top of the law firm is professionally responsible for all the actions of the individuals under them. Public service, blah, blah, blah.
I just have to make some little comment. Yeah, no, because I think this is always surprises people is that, so again, almost 10,000 people have represented, okay, that doesn't include criminal defendants and things, but for injured workers. I have withdrawn when there's been some sort of conflict, in regards to, let's say, something really dealing with a case. Like 90 to 95% of the people that I've withdrawn is because they've called me a name because I'm Jewish, or they've called me a name because I'm gay, that's derogatory. So believe it or not, those are the times. I mean, and I had, between GJRM and Ship and Stone, again, not either of their faults, clients, okay, like, say horrible things to me. I remember yelling down the hallway one time at Ship and Stone where someone had called me names. And John Shook wanted to do vigilante justice, like. But yeah, I mean, so that's the reason why I've withdrawn. And the reason is because if you're going to call me a faggot, then I'm not going to probably want to represent you, and I don't have to. Okay, but that's honestly much more pervasive than any other scenario that comes up in regards to
Excuse me, sir, we don't use those words around here.
I know, yeah, well, I'm using it because I have one. Well, no, it's just, I'm just being, we're not gonna censor anything. And so, anyway, but yeah, honestly, but that actually falls under, if you can't, like, if you're gonna call me that, you think, well, that's an easy one, just whatever. Now, I don't know how that plays in other scenarios and other things like that. Like, if you're appointed by the public defender's office, then it's a little bit different. But like injured workers, like, because what is it, the word repugnant? If you find one of the clauses in professional ethics is like, if you find the client's interest so repugnant that you can't be an advocate, well, those people would fall into that category for me, okay? And so why would you want, like, it just doesn't work, okay? But, oh yeah, like I had well, I guess I can't get into what they've, specifics they've said to me.
And we've got a time issue.
Oh, you have a time issue, so we need to shut up. But anyway, it's not, but that's why I've withdrawn mostly. Okay, that's like 90% of them, I know. And yeah, poor me. No. Kidding. Yeah.
And we've had to do some similar stuff before, where that we have, on smaller scales, right, from most of what our clients are, but where we've represented maybe an uninsured employer, right, in a criminal /DIR matter before the courts. And we find out that they have like this history of trying to defraud their employees by paying them under the table instead of having them go through work comp, right? And all of a sudden you're like, wow, that goes against everything that I stand for personally, we stand for personally, and maybe it isn't somebody calling, like, just outrightly discriminating against me with hate speech, but all of a sudden it's like, I can no longer represent based upon the dark nature of what they're asking for us to do or to perpetuate. We just can't do that. So you terminate the relationship. I think that's probably similar in the industry generally, and your ethical responsibilities as well. If you find out that one of your clients one of these employers are doing, something so nefarious that it really has an impact, you have to think about discontinuing that representation, both from a fiduciary standpoint and from an ethical standpoint.
Probably a TPA would have a difficult time, but I used to represent the uninsureds, and I would notify our underwriting department, and they would contact NCCI, and we would terminate their contracts.
Right. So getting into it and we'll just do this real quick before we take a break.
I say we just keep going. If
Oh, you guys-
somebody has to go,
I actually just put a breather.
Yep.
You did, okay.
So next we're gonna get into your code of conduct, what your license is based on in the industry, and standards of conduct.
Okay, let's come back at, 5 minutes.
5 minutes, that's good.
Oh,
Everybody-
5 minutes, 11:15?
Yep,
Okay.
that'll work.
11:15, 5 minutes, quick break.
Yeah, we only have 5 times as many slides to get to. It's okay.
We had a guy one time, he said he was an accounting firm, and it was a contractor, it was a construction firm. And everybody thought that was an accounting firm. Everybody here does construction, and I sent it to underwriting, and underwriting's like, figure out. But we could do that, and NCCI then would just say, you're out of business because you can't.
Yeah.
Because we're the insurer of last resort. I'm good. No, I'm authorized to, I'm only authorized to work 5 hours a day, and so I have therapy at 1. So, yeah. Thank you.
Yeah, exactly. And, my frustration is, I'm not supposed to be sleeping on Zoom.
Where you been?
Tell me that. I'm not gonna do that.
No, we got an offer.
So the 29th, no, right after this. So. And then 3 weeks, 3 weeks on Monday, so, yeah. So my mom is sick, my mom's sick, so my husband's just recovering from his. And so there's no downtime here. Are you So I used to have I'm insurance, right, NCCI, and we used to get classes on how to
No, it's not, but
They're ridiculous when they're going to and if you're entitled to it, like, your work sucks.
Now I want you to take your all
And so I was like, this is what you need to do and why. This is what you need to do and why. And I the statute and how it takes that. And I was really educating her. I wasn't trying to be mean, but I was like, this is what you're not doing, and this is why you need to be doing it. And so I sort of called me. She goes, do you not like your district? I go, well, she's young, and you're your supervisor. So I educated her, and making sure that my friends were around. I go, I have no problem training. I almost feel like I need to go back into the industry and train because I had a lot of I don't have to see the maybe that goes okay for other employers, but I know they do everything on their file.
It says in the Bible, if the Lord insulted, I don't know, I wouldn't really on
I got to see her before, the day before, and so it's funny because Leslie came, and I know Leslie's crossing and then upstairs telling her story. And no legal issues. I go, it's okay. I go, let me tell you what's really happening on this file. And I gave them, I don't think there are 13 issues that appeal right now. How do you not know there are 13 issues that appeal? And Leslie's like, taking notes and the whole girl just goes on with the next. I'm telling you, in my favor, you're deciding on the playing field because you don't know. Right. And I never let my friends go to the without looking at the review and making sure that it was accurate. Where's the oversight? And I don't know if it's just these insurance companies don't think it's important or they're putting too much burden on the supervisor. These are young adjusters who are learning. They're not getting any instruction. You're doing them a disservice. So, I don't know how I will tell you, I went to the county. I thought I'd be fine. I was taking out but I learned it, right? I was like, learning opportunity, you know.
All right, let's get back to the seats.
It is.
That's what I do.
That's right. Okay, we're gonna start with our Kevin for a minute.
Testing. Everybody back?
Because Kevin had, I think Kevin had.
Yeah.
All right, let's keep going.
So I'm gonna start without Kevin.
Oh, life without Kevin. What was
Just understand that we still have some participants from the other side in there, so we can't get totally crazy. Just kidding. Okay, so let's talk about adjuster professionalism and ethics. NRS 684A 165. Who has read this? Not in one of these presentations. Who else has read this? Who reads it regularly?
Jesus, Ann. But you don't follow it, no. I'm
So,
just kidding.
oh, Chrissy, that's not
I'm just kidding.
So I say every time that I have one of these presentations, I think that it kind of falls on deaf ears a bit, but every time that I have one of these presentations, I say you should print this out and you should at least have it on your desktop as a PDF, but you should probably have it on your desk, printed out all the time, because it's what helps you sleep at night. They've made it pretty clear for us in a world that's not very clear, right? So the standards of conduct, this is still effective. I went and checked it, so not just effective in 2018 when I first made this slide. An adjuster shall be honest and fair in all communications with the insured, the insurer, and the public. Get that? 3 different ones. So, honest and fair in all communications with the insured, the insurer, and the public. 2, an adjuster shall give policyholders and claimants prompt, knowledgeable service and courteous, fair, and objective treatment at all times. We'll get back to these, but that's letting the one bad apple spoil the whole bunch. Not allowed to do it. Objective and fair treatment at all times. An adjuster shall not give legal advice. Careful. It's really tough in our form. Insanely tough in what we do. Unlike any other practice of law, any other industry, in work comp, it's really, really tough to not give legal advice, but we're not supposed to. An adjuster shall not give legal advice and shall not deal directly with any policyholder or claimant who is represented by legal counsel without the consent of legal counsel involved.
Can I add something to that?
Okay. Just real quick, Sean is right where, in regards
I
to.
got that on tape.
I'm sorry. No. In regards to the giving legal advice, I'm not going to wade into that. Okay, but I'm going to present a scenario where, again, when it's ethics, it's not just you and your lawyer. There's also the other party as well. So I ran into an issue where, and again, comes with, and everybody's intention is in the right place. It's not like people are, not always, but like in this particular scenario, I got an email, from from a TPA, asking about an AO, that had been there for a while, and there was something along those lines, and they copied counsel, and I'm like, so I picked up the phone to counsel and said, no, I don't care, and I'm CC'd, all that. I'm like, let me flip it around, because again, it's like, no, you can't communicate with represented parties, and that's for lawyers, and then here you're talking about an adjuster where if the person's represented, you can't reach out to them, you need to go through their attorney, Well, the same goes is if you've hired an attorney, and this happens, and you kind of think it's under the fray, and the attorneys find out about it, and we're like, what are you guys doing? Is, adjuster and my case manager will kind of be like, yeah, let's kind of work out this, again, with intentions being in the right direction, but what you're doing is unethical, And just you as the adjuster reaching out to something, I would just say, you need to consult your attorney. I love the letters that quote all this law and say, this is the law, now give us your opinion. You gotta be careful with that, But like you said, it's a delicate balance, and that's not for me to say. Because I know when I have a letter like that, I authored it or it's coming from a lawyer. But just copying, reaching out in something in litigation, and just CCing your attorney on it, unethical, because you're assuming that might be okay for you and your arrangement on your end, but it's not okay for me because my ethical obligations from the state bar says I can't communicate it with represented parties. So it doesn't mean, well, if they're CC'd, I can communicate directly with them. No, that's not how I read it. And so I lit up the lawyer, and again, we have good relationships, but going, never again, stop doing this. And I was like, and let me tell you, I was like, does it work in reverse? Should I give my client your email address and let them contact you as long as they CC me? Of course, the answer was a resounding no, But just remember, with ethics, it works both ways. So that may have been okay on the insurer TPA's end to do that, But it wasn't okay with me, and I'm not going to respond to a represented party. And having all the time, and you know this, when I get something from an adjuster that is in litigation or that is something that I know, that as long as I know that they have retained someone, I will immediately forward it to them. Because that's on me if I'm going to communicate with an unrepresented party. We are somewhat, and I say somewhat because it doesn't include everybody, We don't, like Sean and I, he's correct. I don't believe that I can think of one situation where we've ever accused each other of being unethical, okay? Yes, we've had some, heated battles and I usually end up winning, but, no, I'm kidding, I'm kidding, yeah. No, but in regards to ethical, and we don't get into situations where, because it's so fluid and we're doing a lot of emailing and things like that, it's that, there are attorneys, defense attorneys, not at agency or former Lewis and Brisbois, okay? There are defense attorneys that have significant problems with certain things that you think, now what? And you think, I'm not doing anything wrong. And they're like, well, this is unethical, and all that. And we're lucky to be in a small kind of sandbox, if you will, where we see each other so much that I have not seen it again. Now, this is also me as an attorney. For me to go to the bar about another lawyer, it would take a lot. And I don't believe in work comp, at least with their law firm, that I would ever be in that scenario, okay? And so, but that's not the case with some of our colleagues, okay? So just always remember, you thinking that, well, what is the big deal? That's one side of the equation, okay? And so you don't know, necessarily the other side, so, yeah.
So I've got a couple of examples for this not giving legal advice, right? So an adjuster shall not give legal advice and shall not deal directly with policy, with any policyholder or claimant who's represented. But this shall not give legal advice, right? It gets you in so much trouble. So many of my cases that get hairy and are very sticky are ones where that legal advice has been given out by an adjuster. Here's an example of something that you think might not be legal advice, right? But definitely is. A previous claimant, right, with a closed claim comes in and says, I want my claim to be reopened, right? I'm hurting again in my neck and I want my claim to be reopened. And what is your response likely going to be?
You better quote the reopening statutes
Okay,
and not
right?
give your opinion as to whether they
So what you might say is, you'll need to get a doctor to certify that you have a worsened condition or a condition that warrants a rearrangement of benefits, right? But the problem with saying you're going to need to get a doctor to give you a certification is that is clearly outright legal advice.
Yeah.
It's just legal advice straight through. What you're saying is in order for you to be successful in reopening your claim, you're going to need to get certification from a doctor. Now, whether you're correct or not doesn't come into it because you're telling them the legal standard and then you're advising them what they need to do to be successful in reopening their claim. It's open and shut.
What are
It's
they
not even up
supposed
for
to
question.
And wait. NIW, I think it is, or the DIR, has a reopening handout. It's a one-page and it outlines everything you have to do. So that injured worker calls you, say, I want to reopen, say, what's your email address? And send that to them, because that's the NIW, tell them how to reopen.
I wouldn't even do that. Let me tell you what I would do. I would do exactly what the law allows me to do, which is to say, we were recently contacted by you with a request to reopen. Your request for reopening is denied. And then I would put the statute for reopening in place and send it out to them. And that would be it. The problem with it is when you try to be helpful, I see everybody, right? Right? You try to be helpful, and the problem is, I would like everybody to respond to this. You've got two lawyers that are trying to tell you how to not unauthorized practice law.
A felony, yeah.
Right? But why would you go in a different direction, Ann?
I don't think it's fair. First of all, I wouldn't deny it because why would I give you guys more money to appeal it? But the other side of that, would be because I don't think that's fair.
I need it. Make sure that I get my next reopening.
I don't think that's fair to the injured worker.
Yeah, my big thing is it's not fair to the injured worker, and then let's say if you send a denial and that denial is not appealed or anything, Isn't it barred from really?
For
I'm
either.
here.
Well, but that's appeal rights, that's not quoting the
Listen,
law.
So somebody
You're
online
trying-
says the statute literally says that, so we can't just read it to them?
You can give them the statute.
Yeah.
What you can't do is advise them of how to satisfy the statute. So listen to the words that I said, which is what all of you say. This is me getting all medieval with you. No, which is what all of you say. What you are going to need to do is go to your doctor and get a note if you want this to be reopened.
No.
So what
Nobody
is
says
that?
Yeah, they probably do.
They do.
Yeah, yeah, of course.
There is obviously, yeah,
There's no reason to sugarcoat it.
there is a quick, sorry, Sandy, there is one small difference, so, in my world, okay, the person comes, I'd like to reopen, I'd like to do all of that, okay? Now, the difference is that, cause like when Sean was talking earlier, he and I on the phone this morning and how he was joking about that, did that potentially create an attorney-client relationship? I have to, like you all, that it's easier for that. I have to be careful there because if someone calls me and genuinely and wants my advice or what have you, and it happens all the time, okay, but mostly in my own world of work comp, okay, if someone comes through the channels and they want to reopen the case, then now us telling them, hey, you need to go, like this, us telling them, you need to go and do all of this, okay, now that is protected. I can give legal advice, I'm a lawyer, okay, and I can do it without actually retaining them because it's we tell them as we're sitting there, I am not representing you, and everything that we say, even though I'm not retained, is protected by attorney-client privilege, okay? So when Sean was joking earlier that his conversation and mine could have been protected, it potentially could have been if he was asking for my advice in regards to criminal law and things like that. And a lot of times you have to stop and clarify. If any of you have ever talked to me on the phone about separate legal issues other than workers' compensation, okay, and there have been, right? I oftentimes will tell you, okay, by the way, okay, this is not, this is either,
I'm not your attorney.
I'm not your attorney, whatever, but nonetheless, even if you call me and say, hey, wife got arrested, this is what happened, on and on, or something along those lines, and I sit and talk with you about it, okay, now, that's protected, okay, and that's confidential, but it is very different. Me as a lawyer, or Sean as a lawyer, giving out that information about what you should or should not do than a non-lawyer doing it. Right. Yeah.
So, I did not renew my adjuster's license or my hearing license. So I am not a licensed adjuster anymore or a licensed hearing representative. However, Leslie works for an employer also, and she's also a former claims professional. She has maintained her adjuster's license and her hearing license. But I still stand by, if an employee comes to me with that package and says, how do I fill out the mileage?
Yeah.
I'm gonna give them instruction on how to fill out the mileage.
Agreed.
If an employee asks me how to fill out the D36, I'm gonna tell them what it says, but the decision is theirs as to how they're gonna answer that question. But if they're asking me how to reopen, I'm gonna give them the reopening statute. I'm gonna instruct them to contact their doctor. I'm gonna tell them the doctor's gonna request cash. And then to submit all the paperwork to the adjuster to render determination. I'm still giving instruction. Am I practicing law?
Yes?
Well, I mean, yes, like you're giving legal advice.
Yeah.
That's what you're doing. I mean, you want to call it instruction. So there's two differences. There's providing legal information, and Chris could weigh in on it too. He's an attorney, I think. No, I'm just kidding.
I think. You're so crazy.
So
is
and
Justin.
Justin as well.
Yeah.
But it was a dig at Chris, not at Justin. I like Justin a lot more. No, I'm just kidding.
We know Chris though. a lot better, yeah.
But you can provide legal information, right? But you can't provide legal advice. That's all there is to it.
So what, just send them the statute and that's your duty?
It's what you should be doing in all of your determinations.
No
Is making a
conversation.
determination and then providing, hopefully on the form provided by the state, but providing legal information that supports your determination.
And how to appeal.
So it's up to them to understand the legalese of the statute.
So,
Yeah.
what if you preface any instructions or advice? Shakira was saying, I'm not an attorney, this is not legal advice.
It doesn't.
However,
then you give legal advice.
Shake their
So
heads.
doesn't that,
It don't matter.
doesn't that sort of go?
No. No, because of what, so in regard to whether you're bound by these adjuster rules of standard of conduct, right? There is a difference. However, with the unauthorized practice of law, which is I think a criminal offense,
Felony.
right?
I'm saying I'm
and it's
not an attorney, this is not legal advice, however.
But you're
if
giving
you-
legal advice,
it
so
gets-
you can say, I'm not a
Yeah.
dog, bark,
Yeah.
bark, but
Right.
you're
Yeah.
still a dog.
It gets a little,
Right.
It doesn't matter.
so
like-
it gets a little bit weird when you are the employer. And when you're trying to point a friend in the right direction. It just gets a little weird.
I mean, it's my job.
Right.
Mm.
But your job is to give them the paper
job is
and let them.
To help them navigate.
But you walk, let's get back to basics real quick before I get this way in, but you are walking a razor's edge when you have experience in the profession,
Right.
right?
Yeah.
And you have all this vast experience. You're walking the razor's edge of this ethical dilemma when you start to put on the hat of an attorney, right? And create the guise, right? Like create this image that what you're giving them has more weight than what they would get from the general public that doesn't have the experience, right? Because you're representing a third party and you're interested, you have certain rules that help you to make sure you don't skirt your ethical responsibilities.
Okay, I am obviously disagreeing respectfully.
Yeah.
With regards to stating pursuant to the statute requirements versus me saying you will need to do this, I always reference the statute and I'll say the statute requires that you submit a written request and go to a doctor and have the doctor submit. We're referencing the statute's requirements, not
What's the next?
Suhair's requirements.
What's the next line then?
Yeah.
That's the question. So
Yeah.
where you're at right now is you're perfectly fine.
Yep.
The statute requires.
Yeah.
But what's the next line?
Here's the statute,
The statute requirements, and then my
make your appointment.
my follow-up to that is once we get both those documents, we will issue a written determination.
You're you're in gray territory for sure, I think.
Well, Jenny, here's the other thing too, flip it, okay, and imagine get out of workers' compensation, okay? And someone comes and says, hey, by the way, my wife and I got into a fight last night and I was arrested, okay? And, you think, well, I mean, I know this may sound silly, okay? But what's the difference if you coming in and be like, all right, well, this is what's gonna happen, okay? You're gonna be arraigned, you're gonna go to arraignment, you're gonna plead guilty, what was your bond? Here's your rights, here's what the jail time you're facing, like all these types of things. That's all in a statute, okay? But you are actually giving legal advice in that scenario, and I agree 100% with what he's saying, is that there are so many times. Now, the remedy is that, are we going to take you and turn you in to the bar for the unauthorized practice of law? No, but you have lawyers sitting here saying, okay, you're really kind of towing the line, and I'll respectfully disagree with you respectfully disagreeing, okay? Because it's not up to you. You know what I mean? That's the whole thing, is that you can say, well, I disagree with a lawyer. Okay, well, let me know how that works out when we both walk into court, okay? And so, but anyway, I mean, so that's what I'm saying, is that just because it happens, or just because you're writing letters, and we are literally threading a needle here, but it's true, though.
So
So
you're
online,
saying, so you're saying what I do, you call me, and I get them every day, I wanna reopen my claim, what's your email address? And I send them that thing. Because I have found that if I say what these people have said, you gotta go here, you gotta do that, it always gets screwed up.
Yeah.
So I don't do any of that,
So-
I just send them the NAIW
Right?
fact sheet.
Which I think that you're probably fine. That's
Uh-huh.
providing legal information, which
Yeah.
is not a felony.
Readily available
Right? To the
everybody.
public, right? You can point them at the statute. Right. But
So
remember,
it says, how do we avoid providing them with the right information if they don't understand the statute?
That's not your
that's not your job.
Yeah.
To help,
Yeah.
right?
Contact the IR, they're the
Yep.
ones who provided that.
Contact DIR,
Yeah.
point them to,
Yeah.
NEIW has the forms readily available, right?
And do you, and then this person that just asked this question, do you understand the stat? I mean, like,
A
that's
lot.
the thing, is you may
Can-
say, oh, I do, I've been around for 30 years or whatever, I'm like, but really to
Can
give, to
you-
advise?
You can't.
You can't.
So, here's where you get in danger. Applying the
Oh, I see
law
danger.
to the facts.
Yeah.
Anytime that you're applying the law to the facts, you're providing legal advice. Period.
So we are
Every
licensed,
single time.
we are a licensed examiner. We should be able to explain the work comp process.
The
Oh, the process, yeah.
You can explain the process and you can provide legal information.
Yeah.
What you can't do is apply that process
Tell them
and
what
that's
to do next.
not even that. You just can't apply that process and those statutes to their set of facts.
Right.
So here's an example of a case that I'm sitting on my desk right now. And I won't tell you names or anything like that because I can't. But email communication, I want to reopen my case, I'm doing a lot worse, right? Email response, right? You need to go and get a doctor's note if you're going to reopen your case that shows that there's a worsening of your condition, right? That's appealed. Okay, email, right? Because this is a pro per, right? This is a unrepresented claimant, right? Then down the road, right? So now it's appealed, so everybody knows that you just provided legal advice. Then down the road, right? We have a guy comes in and says, here's my certification, right? The problem is that we litigate that first one, right? And we actually get affirmed, it's not dismissed, which is kind of ridiculous, right? And it goes unappealed, right? Second one comes down the pipe, right? And now there's res judicata that we're arguing over, right? Which, oh, now we're fancy, Latin, right? But now there's a problem because the person is supposed to wait a year because they have an affirmed denial of reopening, right? It's a huge problem because now we have a determination that's in full effect that is squarely based upon a violation of the ethical standards from an adjuster, right? Now you just hold your breath forever because now you've got this and your license might be in jeopardy, right? Because you violated the law and now it's become the basis for a decision, right? It's just, we all do this all the time, right?
Can we give some more, we need
In that
more,
I don't think we don't have a ton more time.
No, we don't.
But
Well, also, sorry, Sean, also do not, okay, and, one thing, goes even beyond this, do not talk about case law, okay?
Oh.
Do not, if you've got that in your determination letters, get that off, like, that's not, now I know there's the claim acceptance ones that quotes Gilman and all of that, okay? As citing, but, which is, to me, is different than being like, well, because of this case and this case, your case is denied. Or because of this, or if you're a hearing advocate, okay, and you come in and you, like, we always make fun of people like if you come in and you're not a licensed attorney and you talk, well, the case law says this, that's actually been authorized practice of law, even though you have a hearing advocate license.
yeah, so it's applying the law to the facts is a violation. That's providing legal advice. It's the standard that they're going to use if ever, which it probably will never happen,
Right.
that you get adjudicated for this. But the other side to it is that you are in a violation of your professional conduct and your ethical standards. And why are those there? It's to keep you ethical. Does that make sense? Because you're serving two masters. You can't serve yourself and your employer or whoever you're working for, right? You can't then go and serve somebody of the general public because you're biased. They won't allow you to do it by statute, right? But also you shouldn't do it ethically because it's also a moral violation. And I will say this loud and clear, in work comp, no good deed goes unpunished.
somebody just said that. How come everything gets us in trouble no matter what we do?
That is
Oh, wow.
the problem. Let me stand up.
Let me stand up.
Do you want to know why it gets you in trouble? Do you wanna know why it gets you in
Right,
trouble?
right.
Because you're acting unethically. It's a wolf in sheep's clothing.
Yeah.
Do you, that's what this, I love that we get to new things and it isn't
Yeah.
just boring, right, in this
But I
presentation.
love that we agree.
Right, but the problem is, when you act unethically, it's also going to oftentimes mess up the claim and not get you to where you want to be, right? But you're on this thin ice that even the government and the law has said that you can't be on, right? What I tell my adjusters, as I'm making myself look like I'm crazy, but what I tell my adjusters is act as though every communication is in writing. So if you issued a determination, swear it out in paper, that said what you need to do is go to your doctor, right, and get certification for this, certainly nobody will feel comfortable with that because you'd be like, I think I'm practicing law, right? But then you get on the phone and you're like, hey, what you need to do is go and do this. And you feel comfortable with that because you're just doing something that's good. Or you're meeting in person and you're saying, what you need to do is go and do this. The problem is that you might just be wrong or you might be right, but you certainly are applying the law to the facts and giving legal advice, which
Just
you're
give
not
him
allowed
my
to do.
number, I'll
Yeah, okay.
I'm not ethically
But
obligated.
the problem is that you're still walking that ethical line and you're still overstepping your bounds.
Do you think the same applies to like if you do the inverse, the adjuster says, hey, by the way, you know, we've denied that, or, you know, we're not able to reopen or something because you have not provided, like, instead of go get something, you have not provided what we're telling you to go and get or something
That
like
is different.
Okay.
That's different because you're not providing legal advice, you're just telling them the justification for why that you haven't done something. Does that make sense? The different couching of it. What you need to go do is go and do this versus you're unsuccessful with reopening your claim because you haven't provided this. Right? Do you see the difference between the two? It's an important distinction because the problem that they're hedging against with these standards of conduct is that the person then thinks that you're their advocate with the law. The person then thinks that they are able to rely on what you're giving them because you're looking out for their best interest, right? So they start to use you as a source for the law, which is inappropriate. What you should say when they ask you the question, what do I need to do to get my claim reopened? You should say, you can talk to an attorney about that, or you can consult the statutes, right? Here's the statute. What you can't do is provide them the legal advice. I know that it seems like it's cumbersome and that nobody has time for that and that we should be able to, but I'm telling you, I have a dozen cases on my desk right now that I'm in thick and heavy litigation on that are all sorts of screwed up. That one's not on my desk anymore, that's why I can talk about it, but thick and heavy and all screwed up, right?
Because of adjusters.
Because
saying the wrong
adjusters
thing.
trying to do the right thing and to do a good thing. There's a dozen of them, right? And the adjusters hate that claimant forever now because
Yeah.
right? Because they were trying to do something good and it ultimately slapped them back. And everybody's saying the same thing, right? Why does this always happen? It's because we've skirted our ethical responsibilities. That's why it always happens, that it comes back
Are
on.
there ethical questions in licensure for work comp to get your
Yes.
license?
Yeah.
Yes.
These,
I think there's
On the test, there are ethical questions.
10 of them. There's always a certain amount of them on the test.
okay, so online, I have a question as an example of what you are saying examiners should not do. So if we deny a claim, your opinion is, as the examiner, we should not explain to them why it was denied and don't mention statutes that apply and why. What
There's-
I'm hearing is that you want us to say, look at your letter.
Well, I would not get on the phone and talk with them about the denial once you sent out the letter. First of all, that's just my advice to you, right? You can definitely provide rationale for your decision, right? And you're required to provide the statute that you relied upon, right? That's required in order to do it. But explaining to them the process for which they could have done it right or something like that is totally illegal.
Okay. This doesn't help us avoid litigation costs on the file either if we have to defer them to get legal advice.
I will-
NAAW free.
Right.
TIR.
And I will reiterate I'm not trying to get a ton more cases through this training, okay? I'm not trying to get, I'm not trying to get.
Just don't deny anything.
Yeah, right. No, I'm not saying that. But here's the point. The legal advice and the litigation has to be left to attorneys, period.
Don't give legal
Right?
advice.
I mean, and is that gonna cost you? It probably will cost you. But what's going to be a greater cost to you, in my opinion, is providing legal advice or setting up a standard in your workplace where that your adjusters provide legal advice and then trying to get out of that later.
So the ramifications of them actually doing this, it goes to court. Is there an actual hearing about you gave legal advice to your injured worker? Is that what happens when you guys
Can
go
I
to like
step up
hearing
on
or
that
something? Or do you?
I did have a situation where I spoke as if I knew. I know that's shocking. I spoke as if I knew, and the injured worker misunderstood what I said, and we went to court, and I was, what did you say, bitched and berated?
By the judge.
Yeah, by the judge,
Yeah.
because
But no fines or penalties. But you're saying you
But they
could
could've.
lose. You could
they
lose your
could,
license.
no, I'm saying they could have. If that injured worker had had a different attorney, they could have come after me for legal advice. And
Well,
that's
and
the
then
reason
what
why
happens? Does it go to
realty-
DOI,
Right,
Division of Insurance?
So DOI can take your license,
Or the
Okay.
state bar.
the state bar could prosecute you,
and fine
right,
you.
and fine you. And,
As a person or as a company?
As a
as
person.
a
As a
person, individual for
As
the.
an individual under the company.
So, and they could find, the courts could find you guilty of a felony, right? But the more likely scenario is that you lose credibility in front of the administrative courts and in
That's
the
right.
industry.
Yeah.
Right.
That's the big problem, the middle finger, no, the big problem is
We have to
that,
go to law school
is
now.
that you got, we'll take somebody who's not there anymore, you've got Mercer Barons, who refers to you as an idiot who thinks that they can practice law.
She just left though.
I know, she's not there anymore.
That's why
but-
you can say it.
But I can, that's a quote, is an idiot who thinks that they can practice law. And she used to say stuff like that all the time. And sometimes it was well founded,
Yeah.
right? Sometimes it was like, yeah, sorry, we're trying to work on this.
I'm
Or
trying to
certain
get away from
HOs think they're lawyers
So
themselves.
Leslie and I are sitting here, going back and forth with the people that show up at our desk, right? And they're like, I really hate going to Concentra. And I'll say, well, you have the right to change treating physicians. You can select another doctor and let the adjuster know. Did I just give legal advice?
I really hate going to Concentra. You have the right to do X. That's legal information.
Okay,
You should do X.
Right.
that's different.
Go
right.
and get another doctor. You have
Yeah.
the right to. That is legal advice. Do you understand
Yeah.
the nuance?
Yeah,
Yeah.
okay. So
Here's the
we're
doctors
sitting
we
here going,
recommend.
oh my God, we're gonna lose our jobs tomorrow.
Here's the doctors we recommend. Well, then back to Chrissy's question is that this is where people, in regards to, remember, we're here to talk about ethics, okay? And so we don't have hearings about ethics. I mean, you could, the Division of Insurance and whoever regulates you, okay, if that's what they do, or DIR, and the state bar, which actually would have to be, they would, the DA's office would have to prosecute, I mean, they would have to go through all those channels. But are we sitting in front of an HO talking about the adjuster giving legal advice? No, but to Sean's correct point, which is much more than what you should be concerned about, is that, if you got this letter, and we all know them, we all see them, okay, you got this letter saying, do this and giving legal advice, he is correct. What happens is your credibility on every time that judge sees your name, most likely they're gonna think you're full of it, or they don't trust a word of what you're saying, or not to the point that Mercer says it out loud, okay, that she thinks that, well, you're an idiot and you think you're a lawyer and you're pretending to be a lawyer, and so people sometimes they see that and they're like, screw you, type of thing. And you don't want that.
It affects your ability to do your job.
It does, and just like we don't tell injured worker, like if someone's gonna go and testify, or someone's gonna go, or like with their conduct with their own employer is like this, it's like, look, you can hire a lawyer, we can go and litigate, things like that, but at the end of the day, you still have to work there. So I can't give you advice on walking into work every day and how to conduct yourself
And even if you're in the right, okay, but like I don't have, I call it practical advice and legal advice when people come to me. The practical advice is, do you still want to keep your job? Because if you go in and act like an asshole to the employer, even if you're in the right, you're only creating problems for yourself. Well, that's not legal advice. That's just life, you know? So, you know, that's a thing too, and that's where, or your own credibility, you know? Like back to the D36. Do you know you just kind of created a problem for yourself here when you just can't seem to remember this major motor vehicle accident a year ago? You know, I mean, type of thing that you didn't tell us about either. I mean, so it just all comes back into this, but remember this is ethics. And and it should be noted in this audience that, I mean, Sean and I agree like 100% on what we're talking about here.
Never happens. Yeah.
Which means
Which never happens.
We're on this and right since we agree.
Wait, I have one more. So
Here,
is
let me
it?
interject this real quick before before that question or comment. What we're talking about doing is a twofold violation, by the way. Right? Because one, you're not allowed to give legal advice, period. That is in regard to anybody. That's in regard to your employers, right? It's just regard to anyone. But now we're talking about giving legal advice to an adverse party. So I can't talk to his client, but I also, as an attorney, I can give legal advice. I can't give that legal advice to an unrepresented claimant, right? Because that's an adverse party. I'm not allowed to do that, right? As an attorney, I'm not allowed to do it. And so think about that. When you have an adverse party that's coming to you and saying, how do I reopen my claim? And then you provide them legal advice, it's a twofold violation of not just the statute, but ethically. Because of what I just said, they're now going to think that you represent their interests. That's super confusing.
Yeah.
And when you break that off, it's going to be a bad pull of a Band-Aid, right? But also, you're on shaky ground because you don't have that government stamp of approval saying you're allowed to do this because, and believe me, my clients generally are more familiar with many aspects of the law than I am as a specialist, honestly, right?
Not mine.
But
yeah.
they don't carry the same weight. They don't
Yeah.
have to carry the same insurance for providing that legal advice. There's not the same recourses that you can take, and they don't have a governing body like the state bar to slap them on the hand or in the pocketbook when they're wrong about it. And so that's why you have this twofold violation going on. One, it's an adverse party, and two, you just don't have all those other mechanisms to ensure that the advice that you're giving is proper.
A great point. Yeah.
Probably last question or comment.
Yeah, because we need to move.
Is
I've
it
been through almost all
also?
the slides.
Is it also ethical? So this is for an attorney question. Is it also ethical for an attorney to respond to our emails or calls? If we do not respond, we get in trouble as a de facto. Does that work the other way around?
Emails and calls, I'll answer that.
Well, the way that's phrased, emails and calls, there's no obligation. If you are, there's a letter written to you, you have a legal obligation to answer in 30 days. Is it unethical for an attorney not to respond to your emails and phone calls? And the answer is no. Doesn't mean you shouldn't, I mean,
Okay.
okay.
Let me give a caveat then.
Yeah.
Which attorney?
No!
Is it unethical for me not to respond to my clients' emails
Yes,
and calls?
right.
100%.
Yeah, you're right.
Okay.
So if it's their attorney,
Yeah.
I have a duty to communicate with my
Yeah.
client,
Okay.
right? If it's opposing counsel,
Then they
there's-
require a letter.
they don't know. They don't owe you a duty at all.
Yeah.
There's no duty except for to the general public,
Right.
but they don't have any specific duties to respond to an adverse party at all. So, except for to the extent that they're representing their client.
Right.
Does that make sense? So if they don't file an opposition to your motion, there's no breach of a duty to you. There might be to their client, or there might not be, because they might have discussed, we're not gonna file an opposition and just see what happens. That's
So
their
if they
own
come
strategy.
back, if an adjuster says, hey, I wanna schedule your claimant with X doctor,
Yep.
in 2 weeks, and you don't respond, that he has no you have no obligation to respond.
Did they
to
send a letter?
Okay.
But
See, and that's,
actually, no.
what
they
Kevin
can-
is saying is so
I have
irritating.
no ethical duty.
Right.
Well, they answer, they.
Yeah,
But
I
it's
just
true,
wondered,
that's
ethical.
exactly right.
Well, the question is there an ethical duty?
Right.
No.
Okay.
Because
No.
it doesn't owe you anything.
Yeah.
But the adjusters have to wait for your approval to send your patient to X, right?
No,
No,
I'm not aware of such.
Well, like, let's
No.
say you guys choose a doctor, or you guys will write the
Yeah.
letter.
if they issue a request to you,
And so let's say that doctor
That's
is
different.
not available, and now the adjuster has to
I'll go
give
to
the patient to a new doctor.
Should have
If they email you and say, hey, Dr. X isn't available, can we use this doctor? You have no obligation to email them back, because
No. Ethical.
Wait, right. So why do you have an obligation?
Right.
As an adjuster? Let's go back to it. I mean, I know that we didn't spend much time here and we're even out of time now, but why do you have an obligation? Right, why? Because who are you actually communicating with?
a claimant? What do you mean?
Correct. When you're communicating with Kevin, you're communicating with the claimant because the claimant has asked you to communicate with them through Kevin, right? So when you're communicating with Kevin, you're communicating with the claimant. Now, because this is not easy, the state has provided guidelines for how you maintain your ethical responsibilities as an adjuster, right? Being a professional, regulated person in that capacity. And it states here, an adjuster shall give policyholders and claimants prompt, knowledgeable service and courteous, fair, and objective treatment at all times. Now, this is in regard to your licensure, right? But it's telling you how to be ethical in your capacity, right? It's different than DIR coming in. And somebody said, yeah, we're regulated by DIR and DOI. The regulator for whether you're acting ethically as a claims professional, as an adjuster here, is DOI. They're the regulator for that. The DIR's regulation extends to whether a file is being handled properly, a claim file, right? Specifically, a work comp claim file. Division of Industrial Relations regulates that claim file and whether that you acted in accordance with the Industrial Insurance Act. Notice this is not in the Industrial Insurance Act. This applies to all insurance adjusters across the state of Nevada. You just happen to have a foot in both areas. And so that's where we get that from. You're communicating with a claimant, but again, Kevin, in his capacity, other than just the fact that you're in the public generally, right, owes no duties to you. He can't lead you astray, he can't lie to you because we're not allowed to do that to the public generally. But he doesn't have to respond to you, period. So, and with that, it's a terrible place and negative
Okay,
place.
I do have a
Go act-
question.
Go act ethically.
Do you think that with that statute in 684A165 that we could do another topic on that for like an hour straight of just ethical
Wait.
obligations?
Wait,
as an
Wait, let me
adjuster?
flash back when I said, oh, I think the ethics should be directed at the adjuster and not the attorneys. And that's exactly right, and that's why IRMA produces 3 different, classes on an adjuster's ethics.
Where is that?
IRMA.
So as an adjuster
Irma
working for an
dot com?
insurance company, we had to take an adjuster's ethics class
Right.
every 2 years.
And
What is
it is
IRMA?
my
Is that
sincere
the
hope that if I'm
website?
still alive next year, that's what next year's will be,
Yeah.
is an adjuster's directed.
And
Well, what if we
Truthfully-
just put together maybe like an hour of one of our upcoming topics to just go over that?
Not an hour.
It's not an hour?
We tried to convert this as best as
And
we
you did.
could
Yeah.
And you did.
to adjusters. Hey, here's the problem. You know what the problem is?
Your
It's not
attorney
me.
is not adjusters.
It's not me. No, I mean, I could work with you guys on this aspect of it. I feel like I've become pretty specialized because we've done this 50 times. But here's the problem. You always, because there's the overlap with litigation, because we go out and litigate, you guys just want to ask us all the sexy questions about
Right.
litigation.
Right.
And that's the problem. And,
Right.
and then we want to respond to it because we're
Right.
conceited and egotistical. But we want to respond to those for you. But yeah, I mean,
Yeah.
I think it's much more fun talking about your ethical responsibilities than talk about mine.
Than ours.
Yeah, because I like to blame you. I mean, this
Yeah.
whole dialogue
Yeah.
just now about like what you're doing wrong
Uh-huh.
is way better to talk about what I do wrong.
Well,
Okay,
and
what
that
is
also
IRMA?
leads off-
And where can they find it?
Well, and that-
IRMA.
And then
Dot
also
com?
leads off with,
Yes.
like, you know, we only touched on, like, because this isn't, Sean and I aren't here to talk about our own ethics. ethics, because that is between lawyers. It's not between any person but a lawyer to lawyer at all, especially in our
But
world.
It gets weird because I'm an extension of you, right? When I go and represent you,
Right.
and so then and he's an extension of his client, like what we just talked about. So he's representing the claimant, and so it does get weird, and that's why we sort of go in that direction. But we can certainly do another presentation
Yes.
that just
Well, do you think-
starts and finishes on the.
Yeah.
On that statute alone, or, yeah.
Yeah.
I mean,
And
we
do you
can
think
talk
it'll
for-
take an hour or 3
Oh
hours?
no, it'd be longer than an
It's
hour.
longer, because it's not, this is the Nevada statute that outlines
The
what
adjuster's
Nevada,
responsibility.
but it's not exclusive, conclusive,
Right.
or complete. This is just the highlight.
Yeah. So ethics is way wider than this. We talked about ethics generally, and now we've shown you the statute that helps guide you in it. But remember, the two have to be taken into consideration together.
Yeah.
Act ethically generally,
And we
and then
can,
also
Yeah.
comply with the statute.
we don't have
Okay.
to do it as ethics, we can still do it as workers' compensation under CERCLON and still
Yeah.
get credit.
Well, yeah, we can do it whatever. Yeah. Thank you.
Thanks, everybody.
Thank you very much. You guys are alive.
I know.
Okay, we have some raffles to do, so don't leave.
I think I need to install the carols
Okay, if you guys are in person and you did not get a free raffle ticket when you came in, please see Laura. Everybody got one?
And I really want to tell him, if I'm going to, I have to. And am I giving him legal advice if I say file?
Can you guys still hear online? Because Sean took his computer out. I just want to make sure online you guys can still hear. Okay, fantastic.
I'm going to hand him to you. Thank you.
Let me know what happens.
Yeah, absolutely.
All right. I know, right? All right, our first gift card is from Eagle One, Laura Garney. It is a $50 Amazon gift card. Winning number 870, in person, 870.
Those last three numbers?
That's you. Me?
870, Suhair, awesome.
All right.
Our next one is another $50 Amazon gift card from TBJ Consulting. Winning number is 863. 863 in person.
It's still you, Sue here.
Oh, wow. Shake him up.
All right, the next one is a $50 Amazon gift card from TBJ Consulting. Winning person, Marisa Garcia online. You just mail it to her. Or send it to her and keep that for next time. Oh, is it she? 863? Yep, you're good.
Oh, you can take this with you? Okay. Congratulations.
Oh, Marissa.
Ooh, yeah.
That's mine.
This is a dark chocolate sea salt caramels and a Panera Bread gift card.
Get the right number.
From Nevada Orthopedic and Spine. They already left.
Yeah.
In person, 884. 884. All right.
Sorry, Ann. It was in out of the red first.
Well, you know what, my endocrinologist thanks you, but I
Okay, this is good because she was very talkative on this chat today. All right, our next one is an e-card from myself, KB Consulting, and my clients. $50 Amazon gift card to Veronica Munoz.
Right on. Thanks,
Veronica Munoz.
We appreciate you participating.
We can do, we could do 2 yellows and a blue. How about that? Okay, our next one is also a $50 Amazon gift card from KB Consulting, and that is to Glenda Lee Jackson online. And our last online is a $50 Amazon gift card from KB Consulting, and it is Jacqueline Guzon. Jacqueline.
Is this the grand prize one or what?
Yep. No, we got one more. The blue. I have another $50 Amazon gift card. This is an e-card, so if anybody that wins here, just email me and I'll send it to you. 891. 891. Trudy. All right. Yeah, just remind me. Oh yeah, true. Thank you. Okay, online. Give me some more, because actually Trish has 2 Kate Spade purses.
What?
So, Trish, hopefully you're listening and you can get these down. So we have a black and clear Kate Spade purse, and that's gonna go to Bernadette Gerlin, Markel.
Blue or yellow?
Blue. And then the next one is a pink Kate Spade purse, and that's gonna go to 854. 854.
God bless you. I thought maybe you were crying.
That's you. All right. So Trish, you got one to Bernadette Gerlin, the black and white, and the pink one goes to Laura. All right. This one is an in-person. This is from CPK. Billy Marie Morrison always gives us these beautiful purses. This is a Coach purse and a wallet inside from CPK, and the winning number is 871. 871. All right. Is it?
I got it.
Oh, it's you? Okay.
It's not you, Trudy, it's his. It's his.
Yeah. Do you have a wife at home? Because she'll love it. Yeah. Yeah. Okay, you guys, thank you so much. Appreciate it.
So they asked for it to be reopened last week. If she has not responded to it, she needs to. I would say, sort of Dr. Stephanie's report on 115, but there is no, he's rescinded the request to reopen it. Like, I'm just worried about that. Oh my God, those smells are lovely.
Oh, thank you. Thank you. Yes, of course. I still haven't heard from Joe. It's going.
I don't know what's
I
going
don't
on
know.
lately.
I don't know. He must be super busy with school and work and the whole bit and, yeah, so I need
But I'll
to-
be there for sure if he doesn't.
So
leave
you and your
someone else.
husband?
I don't know if it will be me or my husband, but if he doesn't go, I'll
Can you
take my
let me
husband.
know, like, by next, like soon?
Yes.
So, cause I have other people I'm gonna put in spots if I can,
Yeah,
you know,
of course.
get everybody.
But for sure, I'll be there.
Okay.
It's at 9, so yeah.
Okay,
It should
cool.
be okay, but I'll talk to Joe. Because I don't know if he wants to go or I can just take my husband.
Yeah.
If he wants to go.
But I have 4. I have you down for Joe times 2 and you times 2.
Oh, perfect.
So
Okay,
if
so my
you-
husband is missing.
So he's going, okay,
Yeah.
so you and, so at least 2.
Yes.
Okay,
Yes.
and then we just need to confirm if Joe's gonna go.
Yeah.
And then that's it, if Joe has to. So she's from home health.
Yeah.
And this is Sue Harris, Sue Harris with Broadspire. And then Ann over there, she's from Cornell. Leslie is from City of Henderson. This is Sunny from my home health company.
We met outside. Yeah. I'll let you know. Yeah, here you go. I'll send you an email. I'll send you an email.
You did?
I will.
Oh, thank you.
That way you'll have to.
Okay. Oh, 100%. And we actually do have one more for that Tom. And I think we need to go into that. Because there were so many questions and so many issues. And honestly, we can still do it as compensation. We have to label it as ethics because people already have like 3 hours of ethics, you know? Is this mine? No, those are, yeah, but just I'll remember, just text me.
Oh, you gotta eat, you gotta.
But I need to like tape those or like the little name tags so I know who to give them to.
Do you have a tape?
I don't know where the tape is. I need to tape my tags. Or you know what? Just give me the yellow things. And then I'll just keep those.
You're a flyer.
No. When I put in, I put in a request. But then
I take a DJ.
so I emailed them, waited 2 weeks, and I finally wrote them and said, listen, we got to get our flashlights together, and like nobody's emailing me back from your last week's water district. So she, after having a meeting, what you got? Like started helping me. So she's like, listen, we could do it on the 21st. Are you okay? And so that's what we ended up doing.
You know. Yeah, no, I can't. Yeah, he's meeting me, so I have to.
Well, normally.
Next week I'll be live.
Laura Sanchez, Woodlawn. Oh, yeah, this is Sue Harris. You know Sue Harris. Well, she does compliance. She's on yeah. Yes, the last one. Thanks for coming, Laura.
Apparently that bothers me. And so that's the reason is because I'm always
So it was only just, it just happened to be that this day was kind of small. But normally we do have a lot, you know?
And I have a right now she's